Te vemos, te vemos. Obrigado, Shmuel. Bom dia.
Olá,
Bom dia.
bom dia. Então, começamos?
So
Podemos
should we
começar.
start? Yes, we can start.
Ótimo. Ok.
Excellent.
Bom dia no
Okay.
Brasil
Good
e
morning
boa
in
tarde na
Brazil
Alicante e no resto da
and good
União
afternoon for
Europeia.
Alicante and for the rest of
Bem-vindo
the
ao evento
EU.
de hoje. O
Welcome to
meu nome
today's
é
event.
Matisse Dixhorn e eu
My
sou a
name is
mestra de
Matisse
cerimônia do
Dixhorn,
evento de
and I'm
hoje
the master
e
of
de amanhã.
ceremony for the event for
Damos
today
as
and tomorrow.
boas-vindas às jornadas
We'd like to
virtuais
welcome you
Green
to
Gateway,
the
o uso
virtual
de direitos
workshops
de propriedade intelectual para
Green
promover
Gateway,
o
the use of
comércio
intellectual
sustentável
property rights
entre o
as a way
Brasil
to
e a
promote
União
sustainable
Europeia.
trade between Brazil and the
Hoje é o
EU.
primeiro dia do seminário
Today
de
is the
dois
first
dias,
day of our
chamado
two-day seminar.
Impulsione a sua
The
marca
topic
no
for today
comércio
is
sustentável
Boost Your
com a
Brand in
União
Sustainable
Europeia.
Trade with the
As
with the
jornadas
EU.
são organizadas pelo
These
Instituto da
journeys have been
Propriedade
organized
Intelectual
by
da
the
União
European
Europeia,
Union
o
Intellectual
EUIPO,
Property Office,
junto com
or
o Instituto
EUIPO as we
Nacional de
call it,
Propriedade
together
Industrial do
with
Brasil,
Brazil's
o
National
INPI,
Institute for Intellectual
a
Property,
Federação das
sorry,
Indústrias
Industrial
do
Property,
Estado de São Paulo,
INPI,
a Fiesp,
the São Paulo
e o
Federation of
Serviço de
Industries,
Aprendizagem
FIESP,
Industrial, o
and
SENAI, do Estado de São
SENAI,
Paulo.
Brazil's
No contexto
Industry
do
Training
projeto de
Service for the
cooperação
State of
em
São Paulo
propriedade
chapter.
intelectual, financiado pela União
This is an
Europeia,
event happening in
ao
the
invés
context
verde,
of
direitos de propriedade
within the
intelectual.
context of the
As
Cooperation Project
jornadas
for
são
Intellectual Property
transmitidas ao vivo desde
AL
Alicante,
Invest.
na Espanha,
AL
onde
Invest
o
Verde
EUIPO
Intellectual
tem a
Property
sua
Rights,
sede.
which is financed by the EU.
Os objetivos
The
principais
journeys are
da
being
jornada
broadcast
são
live from Alicante in
fornecer aos
Spain, where
produtores
EUIPO
brasileiros
has its
o
headquarters.
conhecimento e as ferramentas
The main goals of the
necessárias
journey
para
are to provide Brazilian
aproveitar os
producers with
direitos
the
de
knowledge
propriedade
and the tools
intelectual,
they need
em
to
especial
make use
hoje,
of
marcas
intellectual
e
property
amanhã
rights,
desenhos,
particularly
como ativo
marks for today
intangível
and industrial designs
estratégico
for tomorrow,
para aceder
as
ao
an intangible
mercado da
strategic
União Europeia.
asset in
Antes
accessing
de
the EU
começar, algumas
markets.
observações logísticas.
Before we begin,
Caso
a few
tenha
housekeeping
alguma
notes.
pergunta para os palestrantes,
If you have any questions for our
certifique-se de
speakers,
digitá-lo no
please make
chat,
sure to
pois haverá
type
uma
it in
sessão
the
de
chat window,
perguntas e respostas
because there will
no
be
final
a
de cada
Q&A
sessão.
session at the end of each session.
Observe também que há interpretação
Also note
simultânea
that we have
disponível
simultaneous
entre o
interpreting
inglês e o
today
português e
between English
vice-versa.
and Portuguese and vice
Pode
versa.
escolher a idioma
You
da
can
sua
choose
preferência,
the language of your choice by
selecionando o canal
selecting
de
the
áudio
corresponding
correspondente
audio
nas
channel in the Zoom settings,
configurações desse
particularly
reunião de
using
Zoom.
the button on the bottom
Please
of
note
your
that
screen.
simultaneous interpretation between English and Portuguese and vice versa is available in Zoom by selecting the audio channel of your choice in the Zoom settings. Além disso, receberá uma pesquisa de satisfação
You
de
will also
usuário
get
após a
a user
conclusão das
satisfaction survey
jornadas.
after the end of the
Ficaríamos
journeys,
muito gratos
and we
se
would be
pudessem
very
preenchê-las,
grateful if
pois
you
a
could
sua
fill the
opinião
survey.
é muito importante
Your
para
opinion
nós.
is really important to
E por
us.
fim,
And
observe que
finally,
uma foto de
remember
família
that
será
we will
tirada
take
hoje
a
no
family
final do
picture
evento.
at the end of the event today.
Agora passaremos para a próxima
We will
parte da
now
agenda da ordem,
proceed to the next part of
começando
today's
com umas
agenda,
palavras de
beginning with a
abertura
few
das
opening
entidades
remarks by
organizadoras
the
do
organizing
workshop de
entities
hoje
of
e de
the
amanhã.
workshops we're having
So
today and
without further
tomorrow.
ado, we will start today's event with some opening remarks by Antonio Berengue Reguant, Deputy Director of the International Cooperation Area of the Cooperation and Partnership Department at the EU IPO. Antonio, the floor is yours.
Thank you very much, Martís. Good morning, ladies and gentlemen. It is a real pleasure on behalf of the European Union Intellectual Property Office to welcome you to this event entitled Boost Your Brand, Sustainable Trade with the EU. I must apologize for not being able to speak Portuguese. Gratefully, we have some translation that allows us to follow my few words of welcome. That I'd like to start by extending a greeting to the fellow speakers in this opening panel, in particular Mr. Shmuel Cantanhede, Director for Trademarks, Designs and Geographical Indications at the Brazilian Institute of Intellectual Property Rights, our strategic partner in the region, but also to Mr. Mateus Palucci de Campos, Manager at the Federation of Industries of the State of São Paulo, and last but not least, of course, my dear colleague from the European Union delegation, Kalin Ivanov, in charge of trade and economic affairs. I think the presence of these different partners today here is a vivid witness of the collaboration and the spirit of cooperation that we all have with a view to propel the use of intellectual property rights in the framework of trade, and in particular, trade between Brazil and the European Union. From our side, EU IPO is within our mandate, and it is our vocation to always promote the use of intellectual property, whether they are trademarks, designs, geographical indications, as a tool that fosters competitiveness, innovation, and trade. Intellectual property is not an end by itself, but something that helps a greater cause. This is something that we have cultivated and nurtured in our relationship with many of our international partners. I want to here spend 1 minute underlying this very solid working relationship that we have with the Brazilian Institute of Intellectual Property. INPI, we have been working for quite a long time in a number of areas. We have been doing work in convergence of practices. We have been working on tools. We have been sharing experience. It is a strategic relationship we care a lot, and we will continue to cultivate moving forward. I think this is a relation that owes some of its strength to the fact that in the last few years we have had 2 projects in the region funded by the European Union, but implementation led by EU IPO, namely Invest Verde, the project that today organized this event, but also IPKey Latin America. This has provided us with a platform in which we have been able to consolidate and fortify some of the gains that we had already started working on earlier in the day. There are many achievements. I will not go into great detail, but let me perhaps just share with you that moving forward in the next couple of months, we have a couple of important deliverables. First of all, one study that we hope to deliver in December, trying to quantify the contribution of IPR intensive industries to the economy and the trade of Brazil, in particular looking at the green IP rights, such as green patents, and sort of showcasing how intellectual property can help sustainable trade. This is going to be a milestone, and we look forward to the delivery on this activity. And also, perhaps worthy of note, the activity on Inventor on geographical indications. This is a series of mentorships where the project has helped identify experts on geographical indications with a view to fortify and consolidate some of the nascent geographical indications in the region. These are just 2 of many activities and contributions that in the context of this project, EU IPO and INPI are doing in the region. Moving forward, at least as regards EU IPO, as we start a new strategic cycle, we are eager and enthusiastic to embrace new opportunities of cooperation with Brazil and with INPI. As I said before, you are a strategic partner. You are our gateway to an important country for us, such as Brazil. We are very much open to also carry on cooperation with other actors, important actors of the economy, like FIESP. We believe that some of the problems of today require us to be pragmatic and address them. So cooperation with private sector, public sector together, very important to start building IP alliances that provide responses to today's world. The seminar that we have ahead looks very interesting. You have some of the most accomplished leaders, certainly participating. I think the topic is very interesting. EU still is of economy, and I would very much hope that the discussions participation. IP, again, comes back to a great instrument that fosters trade, improves relations between Brazil and the European Union. And on that positive note, thank you very much again for your time, and I wish you a very good 2 days of discussions.
Thank you very much, Antonio, for your words. Agora damos a palavra a Shmuel Cantanhede, diretor de Marcas, Desenhos Industriais e
We'll now
Indicações
give the floor to
Geográficas
Mr.
do
Castanhede,
INPI Brasil.
Director of Marks,
Shmuel,
Industrial
a palavra
Designs, and Geographical Indications for ANPI Brazil. Shmuel, you have the floor.
Quero saudar a todos.
Thank you very
Bom
much,
dia a todas
Martins.
e todos.
A good morning to
Saudar
everybody.
Eu, Ipo, na pessoa do diretor de cooperação e parcerias.
Thank you very much for your
Berengue.
opening remarks, Mr. Antonio Berengue,
Também
for
saudar
your
Fiesp e Senai.
kind words.
São parcerias.
And
pra
also
nós
would
do
like to
ANPI
begin the day
muito
with my greetings to the people from
importantes. A nossa
Fiesp and
cooperação
Senai.
com a EUIPO vem de longa data.
It's a long-term cooperation that we've had with them,
Que
and it's a very important partnership for
explora
us.
muitas áreas de cooperação, interesses
We
mútuos.
explore a number of areas of
Particular,
cooperation
o
and areas of
evento de
mutual
hoje
interest
tem
together.
realmente programa bastante
And
interessante. E do
this
NPI,
program highlights this.
nesse momento,
The program for today's seminar is quite
tem
interesting,
se voltado para
and it
entender as
finds the
necessidades
INPI
do
at a moment
empresariado
at which
nacional, do
it is
setor
looking
produtivo
very keenly
nacional,
at understanding the
dos seus
needs of
desafios
Brazil's national
de
productive
proteção da
sector.
propriedade industrial, das marcas e dos desenhos
It's
industriais.
trying to understand the
Temos,
challenges
inclusive,
that
neste momento,
our
pesquisa em
businesses face
aberto
in protecting industrial
para
property
entendermos
and
essas
protecting
necessidades,
marks
quais são
and
as necessidades e
designs.
expectativas, tanto
We actually have
plano
a survey
nacional,
right now
do sistema de
going in the
proteção
country
da
to
TI no
understand these
Brasil, mas
needs
também
and to understand
desafios
the
que
country's
as empresas
necessities
brasileiras
and
encontram
expectations regarding
ao
Brazil's
tentar,
IP
ao se
protection system,
internacionalizarem.
and
E
what
essa
challenges the
internacionalização,
country is
a
finding
proteção da
when they
TI é
try to, or
fundamental.
Brazilian
E
businesses are
aqui
finding
temos
when they
uma
try to
oportunidade de
internationalize.
conhecer mais do
So this is an
contexto
opportunity for
europeu,
us
da União
to
Europeia, na
understand a little
proteção
bit
da
more about the
TI,
European
na
context,
perspectiva da
how
sustentabilidade
you
também.
deal with IP protection,
Então,
how that relates to
Desejo
sustainability
bom
in the
evento a
EU as well.
todos e todos. Convido a
So,
responderem essa
I would like
pesquisa,
to
participarem dessa
wish
pesquisa.
everybody a great
Eu
event
sou-
today.
E
I'd like to extend you an
e
invitation to
aguardo os
participate on this
resultados,
survey
inclusive, aqui
that the
da,
INPI
né,
is
feedback
running right
do-
now. And we'll
das
be eagerly
palestras
awaiting the feedback
bom
and the
evento
results of today's
a todos.
presentations. So have a
Obrigado.
great event, you all. Thank you
Muito
very much.
obrigada, Shmuel, pelas suas palavras. Agora
Thank you
passamos a
very much,
palavra a
Shmuel,
Mateus
for your
Palucci de
words.
Campos,
And we now give the
diretor
floor to
na
Mateus
Federação das
Palucci de
Indústrias do
Campos,
Estado de
Director
São Paulo.
at the Federation of
Mateus,
Industries of
a
the State
palavra é
of São
sua.
Paulo. Mateus, you have the
Obrigado,
floor.
Matisse, pelas palavras. Bom dia a
Thank you,
todos.
Matisse, for your
Gostaria
kind
de
words.
agradecer
Good morning, everyone.
a EY na figura
I'd
do
like to
Antônio,
thank
a União
UIPO
Europeia na figura do Cali,
on behalf
ao
of
INPI,
Antonio,
ao Instituto
the EU,
de Propriedade
specifically
Industrial
Kali,
do Shmuel, e ao IPI,
Shmuel
Latin
on
America,
behalf
AL Invest,
of
na
the
figura do
INPU,
Mariano.
and
Esse
Mariano
evento
on
é
behalf
super
of
importante,
AL
porque
Invest,
todos vocês,
Verde.
todas essas entidades
I believe
são
this
parceiros
event is
estratégicos
very
aqui, não
important.
só da Federação das Indústrias,
This is a
mas
very
também do
important
Brasil.
event for us. You
Nós
are
temos
all
trabalhado
strategic
aqui na
partners,
Fiesp,
not just for
com
São
todas
Paulo,
as
but for
entidades
Brazil's
nacionais e
industry.
internacionais já há alguns
We've been
anos,
working with national and
exatamente na
international organizations here at the
não
Fiesp
só
for a
do
long
governo,
time,
mas do próprio
precisely
empresariado,
to
das
sensitize the
oportunidades
players
da
involved in
TI,
this
tanto a
sector,
propriedade intelectual
not
quanto a
just
propriedade
in the
industrial,
business area,
tem
but in the
para o
government as
desenvolvimento
well,
econômico e social do
to
Brasil, da
basically
América
make
Latina
people
e do
see
mundo.
more clearly all the
Principalmente nesse
opportunities
seminário de
that
hoje,
intellectual
de hoje
property
até
and
de amanhã,
industrial
que
property
vai ser muito rico,
offer
principalmente
to
trazendo
socio-economic
boas
development in Brazil
práticas,
and Latin
trazendo,
America. I
oportunidades,
think we'll have a
tanto de
very
desenho
rich seminar
industrial, quanto de
today,
marcas, como
bringing
da defesa
group
da propriedade
practices
intelectual.
and
Eu acho que é
opportunities,
fundamental,
both on the
principalmente para a
management of
sensibilização do
industrial
empresariado
designs and
e
marks,
a
as well as the
criação
defense
de
of
uma
intellectual
consciência
property.
que a proteção da
And
TI, ela
it will
não só
also
é
be
necessária,
fundamental
como
because
é uma
it will bring
oportunidade de
a new
desenvolvimento
sensitization
da
to the
própria
business
indústria,
sector
né, e do
and an
próprio
awareness
país,
to the
dos
business
países
sector
envolvidos. E acho que
that
trazer aí essa perspectiva
protection
da
of
União
intellectual
Europeia, de
property
como
is a
o
necessity
empresariado, principalmente brasileiro,
and an
nesse caso,
opportunity for
do
development.
Fiesp e do INPI,
I
de
think that the
acessar
EU's
os mercados
perspectives are
europeus,
very
de
important for
trabalhar em
us.
conjunto em transferência
We are
de
all very keen
tecnologia,
understanding on
inclusive,
how to have better
licenciamento de
access to
marcas, de
European
desenho
markets,
industrial,
on
e de
how to do
proteger
better
realmente
to
esses
do
direitos é fundamental.
industrial
Então,
technology
o que a gente tem trabalhado
transfers.
bastante é
And
na
throughout these
sensibilização do
exchanges,
empresariado,
protecting
mostrar boas
industrial property
oportunidades.
is
Hoje,
essential.
a gente realmente vai
So
trabalhar
it's
não só
fundamental to have this
com a
event
teoria
here to
do
show
que
good
é
opportunities
cada uma dessas
and to see real cases. It's very important to see that in the seminar we have both the theory and practice. We have the theory and we have the best practices and we have the use cases here. So that's very important. Thank you very much. Thank you very much to give us the opportunity to institutionally support this event. And today and tomorrow will be very important days for us all. Thank you very much.
Agora
Thank
passamos
you,
a
Mateus.
palavra a Kalin
And we now
Ivanov,
give the floor to
especialista em
Kalin
propriedade
Ivanov,
intelectual da Delegação da União
specialist in
Europeia
intellectual
no
property
Brasil.
for the EU delegation
Kalin, a
to
palavra é
Brazil.
sua.
Kalin, you have the floor.
Muito obrigado, Marchese. Bom dia a todos.
Thank you very much.
Primeiramente,
Good
gostaria de
morning to you all.
cumprimentar
First of
o
all, I'd like to
Antônio
greet
e o IPO,
Antonio,
Shmuel do
Bering,
IPC,
Shmuel,
Mateus
Mateus
da Fiesp, em
from
consideração
Fiesp.
que estou
And
aqui
I'd
hoje
like to tell you that
representando
it's
a
a
delegação da
pleasure
União
to be
Europeia no
here
Brasil
in
neste
representation
evento
of the
de
European
relevância
Union
para as
delegation. It's such a
relações entre a União
relevant
Europeia e o Brasil
gathering
no campo
that
da
will
propriedade
reinforce
intelectual.
relationship between the
As marcas
European Union and
registradas
Brazil,
desempenham
focusing
papel
on
crucial
intellectual
no mundo dos
property.
negócios.
Trademarks play a key role in our business world, and it has to do with reputation and values. And in such a very competitive marketplace in global terms, that is very important for us to work together in order to build consumers' trust. And also, I'd like to highlight that this cooperation goes further, and it also reflects upon the negotiations on free trade agreement, and that has a goal of eliminating the barriers that will make things easier for companies that play a key role in that. And it also highlights the importance of intellectual property rights and geographical indications. This cooperation is reinforced by the European Union projects such as the IP Key and the Green Latin American tool, and the aim is to reinforce good practices of intellectual property, focusing on sustainability. We aim to share knowledge and to align intellectual property protection and work together with sustainable development in order to strengthen local capacities and the cooperation with the INPI of Brazil. And also I'd like to acknowledge the important role of Fiesp that has contributed in a decisive manner to integrate productive industry and to the best international practices. And by doing this, they foster the ability of the Brazilian industry to take advantage of every opportunity. And finally, I'd like to also stimulate the Brazilian companies that are gathered here today to take advantage of such important measures and initiatives by reinforcing their trademarks and their designs as well, strengthening the brand and establishing a commitment with the sustainable development practices that will open the doors of the European Union marketing, and that will strengthen our mutual cooperation, because we aim to build bridges and reinforce innovation and cooperation. And I wish you all a very good seminar. Thank you very much, Kalin. And now we are going to the first introduction of the first panel today. Mariano Riqueri Ponferrada, he is an employee of EY IPO, and he is the leader of the All Invest Green, focus on intellectual property rights. Mariano, the floor is yours. Thank you very much, Matisse. Good morning to you all. I'd like to start by apologizing for my Portuñol, the language I'm going to use right now. And besides that, I like to greet Antonio, Shmuel, Mateus, and Kalin for their warm
realçar
welcome
a
and
importância
also
desse
for
seminário.
highlighting how important this seminar is to
Palavras
all of us.
muito breves
So
para
I
apresentar
will be very
a
brief
sessão de
in order
hoje, não é?
to leave more room for session
No
one.
primeiro dia,
And
nesse
this is
primeiro
our
dia,
first
as
day.
nossas
And
sessões
on
vão
our first day,
cobrirão
we are going
tópicos
to
importantes para
be
as empresas
covering
brasileiras que desejam
important
expandir
topics
seus
for
negócios no mercado
Brazilian
europeu.
industry, for the Brazilian
Vamos
industry,
começar
looking forward
com a
to be
apresentação do
present or more
Nathan Weissman,
present
que é
in the
diretor do Departamento de Estratégia
European
e
Union. We are going to
Corporativa
be hearing from Nathan Washman. He
ele vai
is the
compartilhar com
director of
vocês
corporate
insights
strategy and
empíricos sobre
foresight
como a
department, and he's going
propriedade
to be
intelectual
sharing with
contribui
us
para a
empirical
mitigação das mudanças
insights
climáticas e
into
para o
the green
crescimento
economy,
sustentável
focusing on
e
sustainable
também
development,
compartilhar em
sustainable
geral a
growth.
importância
And also,
das empresas
he
que
is going to
são
be
efetivas
highlighting
em
how
direitos de
important
propriedade
companies
na
that are focused
economia
on intellectual
da
property
Europa e
rights
de outros
are
países.
important to the European
Sabem,
Union
na
economy and
EUIPO
also to
temos uma
other
longa
countries'
tradição de
economy.
produzir
We in
informações baseadas em fatos
EUIPO, we
concretos que
have a
permitem
long tradition
consumidores,
of
administrações,
working
formuladores de
based on
políticas tomar
evidence,
decisões
and we
informadas.
also work
Estamos
together
ansiosos de ouvir este
with
painel
the
introdutório de Nathan, que
decision
lançará as
makers that
bases
are
para
focused
discussões
on
que
public policies, and
acontecerá
we are open
no resto
for
da
contributions
jornada.
and also
Em
to
seguida,
hear from
teremos a
you during the
participação da
day.
Mônica
Afterwards,
Tomczynska, que
we
é
are
líder
going
da
to
equipa
be
de
hearing from
examinadores
Monica
de marcas e
Tomczynska. She
desenhos
is
da
the
EUIPO.
team leader
Mônica
examiner of
abordará as
our
melhores práticas
Institute
para o
of the
registro
European Office, and
das
she's
marcas
going
na
to
UE
be
e também
introducing us to
alguns
the best
casos
practice for
jurídicos
registration and also some
que vão ser de
examples
exemplo
of most
importante
relevant case law
nesse pouco tempo que
for
ela
Brazilian
tem, tudo um
exporters.
desafio
And
para
so
fazer
it's really
aquelas
a challenge
apresentações,
because there are
ilustrar
time
sobre
constraints
alguns
for
pontos
such
importantes
an
dos empresários
important
brasileiros que desejam
presentation
operar no
for the
mercado
Brazilian
internacional
users that are
e principalmente
willing
no
to
mercado
go to the
europeu.
international
Depois o
market.
Felipe Coutinho de
And
Castro,
afterwards, we
que é
have
do INPI
Felipe
Brasil.
Coutinho. He comes from
Que o
the
Brasil,
Brazilian
que
Institute
é
of
importante
Intellectual
integrante do
Property,
sistema
and
internacional, não é?
Brazil
E
is an
que
important
é
member
membro
of the
do Protocolo de
international
Madrid. Ele vai
registration
explicar
system,
como
and
essa
Brazil is also a
ferramenta, o
member of the
protocolo,
Madrid
pode
Agreement.
servir
So we are going
para
to
obter
be
registros
listening from him
em
about
diferentes países de
how
maneira
this
eficiente e
Madrid
também
Agreement
registros
helps
do
countries to work in
estrangeiro
a more efficient
que
manner
gostam,
and in an
gostariam de
international
proteger
arena as well,
suas
and
marcas no
how we
Brasil.
should do or how the
Uma sessão
countries
muito
should act to
importante, que
protect
marca também,
their
que é permitida por a
their intellectual property
internacionalização
rights, and that has to do also with
crescente
the
desse mercado.
internationalization of the
Para
markets,
finalizar a
which
sessão
is
de
an
hoje, temos a
ongoing
discussão
process.
conduzida por Rita
And to
O'Neill,
close,
do
we are going to
Departamento de
have
Assuntos Jurídicos da
a
EUIPO, doutora Pilar
discussion that we're
Monteiro,
going to be
diretora do
putting together.
mestrado
Hugo Neal, Pilar
Magíster em Ciências da
Monteiro,
Universidade de
and she
Alicante.
comes from
Eles
the
abordarão
University of
estratégias
Alicante, and we are going to
internacionais
be
para a proteção das
approaching the
ecomarcas,
trademark
a
structure
ênfase nas
and
marcas de
eco-brand
certificação BERT,
protections, and
BERT-UIPO,
besides
nas diferenças
the green
dos regulamentos
certification
europeus
processes
e
that are
brasileiros.
available both
E
in
então
Brazil
vamos
and in the
falar lá de marcas
European Union
ecológicas,
market.
das
We are
green
going to discuss
trademarks,
the green
que
trademarks, as
são,
we call them.
além de ser uma necessidade
And
crescente
this is
no
a
mundo onde os
growing
consumidores exigem cada
necessity
vez
in a
mais
world
produtos
where consumers
sustentáveis,
demand
mercados como o europeu, que
sustainable
certamente
products.
é
And also
nicho
the
para
European
isso.
market, that's the place to go with
Também
that idea.
precisa ter
And
a consciência que tem
we
regras
also
que se
need
aplicam
to
e
be
regras
aware
que
that
estão
some
mudando.
rules
Então,
that
vai
keep
ser
changing. We are in
painel muito
a moment
interessante.
of huge changes, and
Encerrando o
therefore
dia,
this panels
teremos uma
is
mesa
going to be
redonda com os
very interesting. And
participantes
then we
para
have a round
interagir,
table, a
para
concluding
terminar
one,
de
so that
responder às
they
perguntas
can
que
answer
vocês podem
questions you
marcar
will
no
be
chat.
raising here today. You can send them through the
Então,
chat.
vamos concluir
And
essa
then
jornada e nos preparar para
that's
a
the end of the
jornada, o
journey,
seminário de
and we are going
amanhã
to
sobre
get
desenho.
ready for
Então,
tomorrow's
desejo a
seminar.
vocês muito bom
So I
seminário no
wish
nome
you
do
a
Arinvest
very
Verde,
productive
Direitos de
seminar on
Propriedade
behalf
Intelectual.
of AL Invest Green and intellectual property rights. And we do hope that that's a very dynamic day, a very interactive one with questions and comments. Thank you very much. Thank you, Mariano, for your words.
First presentation of today, which will be given by Mr. Nathan Weisman. Nathan has been working for the EU IPO since 2007, following 20 years in the private sector. Was appointed Chief Economist of the EU IPO in 2022 and has recently been appointed Director of the Corporate Strategy and Foresight Department. Nathan will present the first session of today titled Empirical Insights into the Green Economy, Intellectual Property's Contribution to Climate Change Mitigation and Sustainable Market Expansion in the EU. During this session, fact-based evidence on intellectual property's incidence on climate change mitigation and sustainable market growth within the EU will be presented, drawing from studies conducted by the EU IPO Observatory on Infringement of IP Rights about economic impact and environmental protection. Nathan, the floor is yours.
Thank you very much. Okay, we have the presentation mode. Can everybody hear? Yes? Okay, good. Thank you. Okay, so green innovation is a big priority, not only for the European Union, but really worldwide. But of course, we are an EU agency, so we look at it from an EU perspective. And so I will start this part of the day by presenting you some studies that we have done on what we call green trademarks, and I will explain in a moment what that means. But maybe a little bit of background. When people have looked at green innovation in the past, when I say people, I mean researchers, they have tended to focus on patents. And in general, when people think about innovation, they think patents, right? Because patents have to do with technology, with new technology specifically. And so this is the traditional measure. So here, for example, is a graph from the European Patent Office showing the number of patents in specific relevant technologies that have been filed at the EPO by applicants from the EU between in the last 2 decades, basically. So you can see that both in absolute numbers and as a share, you have an upward trend, although there was some decline in the, let's say, in 2015, 2014, 2015, but then it has started trending up again. And when we look at what are those technologies that are relevant, so the EPO have developed a classification of technologies that are related to climate change mitigation. And you see the relevant technology classes there. So it has to do with buildings, of course. We have to insulate our buildings and have them so that they become more energy efficient, for example. Greenhouse gas capture and storage, reduction of energy use in data centers, which is, of course, becoming a bigger and bigger issue with artificial intelligence that uses a lot of computing power and therefore a lot of electricity. Energy generation, storage and distribution, and so on. So these are all technologies that are relevant to green innovation, to combating climate change. And so the EPO and other patent offices monitor the number of patents that are filed in those technology categories. Now, we here at EU IPO think a lot about, how IP rights relate to innovation. Of course, the IP rights with which we are most familiar at this office are trademarks and designs, because those are the two IP rights that that are the core business of this office, and have been so in the 30 years it has existed. So we think that besides patents, you can also use trademarks as an indicator of innovation, any kind of innovation, and in particular green innovation. And why is that? Well, when a company files a patent, it means it has invented something new, created some new technology, something that maybe one day will lead to a product or a service that can be put on the market. Down the line, when that relevant product or service is indeed introduced into the marketplace, normally it will be branded. And that brand will normally be protected by a trademark. Other IP rights can come into play, but here we are focusing on trademarks. So the fact that a trademark in a certain product category has been filed is an indication that there is a product that has been put into the marketplace. And in the end, innovation only becomes relevant when it results in new goods or new services that can in this case, help reduce pollution or combat climate change. So therefore, we decided to look at the trademark filings at EU IPO to see whether we could see a similar pattern to what the EPO saw when they looked at patents. Here, so for the purpose of trademark analysis, there are 9 product categories that you see on the screen that are relevant to what we are talking about, green innovation. So energy production, transportation, energy conservation, recycling, pollution control more generally, waste management, agriculture, environmental awareness, and then a kind of more general climate change category. Okay, so that's our starting point. And so what we wanted to do with this study is basically to look at all the EU trademarks that had been filed since 1996, since that was when this office began accepting trademark applications, to see, how big a share of those trademarks are related to protection of the environment. So what data do we have? Well, we have, of course, our own register. Our own register contains about 2.2 million trademark applications that have been filed in the last 28 years. And when you file a trademark, you, of course, have to describe, you have to indicate what goods and services this trademark relates to. And this is done with what we call the goods and services description using specific terms. So those 2 million trademark applications contain between them more than 80 million terms describing the goods and services that the trademark refers to. And it is those terms that we want to analyze to detect presence of terms that are relevant for green innovation. Now, of these, we have a subset of some terms, 86,000, that are part of something we call the harmonized database, which is basically a listing of terms, descriptive terms, that have been standardized, translated, and are accepted by all the IP offices in the European Union, and many of them are also accepted by IP offices outside the European Union. Why is this interesting? Because this is what we used in order to train the algorithm that we use to detect the green trademarks. So, first of all, we had to decide what is a green trademark. Together with the experts from our trademark department, we developed an inventory of terms in the description of goods and services that are relevant in this case. 900 terms that are classified in those 9 product categories that I showed you in the beginning, product groups, which are further subdivided into 35 categories. And then we had to develop an algorithm which could look through all these many millions of terms and find the ones that belong to this set of 900 green terms. It's obviously, given the numbers, it's not something you can do by hand. And we simply define a green EU trademark as a trademark that contains at least one of those 900 green terms in its goods and services specification. Okay, so just to give you an example how this works. So on the left in this table, you see examples of some green expressions. So that can be words such as photovoltaic or solar heating, wind energy, wind turbine, etc. And they belong to certain categories. So the first 2 belong to the category we call solar energy. The next 2 belong to the category we call wind energy. And together, these categories make up energy production. At the very bottom of the table, you have an interesting example because it's not simply a question of looking through the terms. You also have to look at which NIS class the trademark is registered in. So carbon monitoring is a good example. Carbon monitoring would normally be a green term because it has to do with monitoring the level of carbon dioxide in the atmosphere, for example. However, if it's in NIS class 10, which contains medical instruments, then it has to do with monitoring the level of carbon dioxide in the blood of a patient, which has nothing to do with, which may be important for the patient, but has nothing to do with the environment or green innovation. So the rule in the algorithm, therefore, is that the term carbon monitoring is a green term, except when the trademark is filed in this particular NIS class. Okay, I will not go through the details of the algorithm, but basically we call it machine-supported learning. So it's a mix of machine learning and some human intervention, starting with these 80 million terms. We then took a subset of those terms, trained the algorithm to try to, whenever you do this kind of exercise, you want to minimize both false positives and false negatives. So a false positive would be a trademark that really is not green, does not contain any of the green terms, but falsely is assigned to a green category. And a false negative is a trademark that is considered not green, even though it should actually be included in the green. So whenever you develop an algorithm of this type, you always try to minimize both types of error. Okay, so finally, let's look at the results, which is the more
olhando agora para os
interesting part in a
resultados.
way. So here you see the total number of filings of green trademarks between 1996 and 2022. And of course, the top line, the black line, is the total. The blue line in the middle are filings coming from companies in the European Union, and the red line are filings from companies outside the EU. So you can see an overall growing trend, although in 2022 there was a decline in the number of green trademarks, especially in green trademarks coming from outside the EU. But it's not enough to look at numbers, because of course over the years the total number of EU trademarks has also grown. And so therefore it's also relevant to look at the share of EU trademarks that fall in one of those green categories. And when you look at the share, then you see an equally clear growth trend, starting with back in 1996, about 4% of the trademarks filed at this office contained one of those green terms. In 2022, this percentage was up to something like 14%. And here you see that the percentage of trademarks coming from outside the EU that fall in the green categories is still slightly higher than the percentage of trademarks coming from inside the EU. But overall, we see a growing trend. Again, there was some bit of flattening, let's say, in the years 2012, 2013, 2014, but in the last couple of years, it has started growing strongly again. Okay, so some information about the categories. So you can see that the most frequent category in which these green trademarks are filed have to do with energy conservation accounting for 26% and energy production for 18% of EU of the green trademarks. Other important categories include transportation, which of course has to do mainly with electric cars and the like. As well as general pollution control. And then you have some smaller categories like climate change, awareness, recycling, etc. Okay, so energy, I would say energy is energy-related products and services are clearly the most important ones, followed by transportation. Okay, we then look at, I'm sorry, I have to refer to my notes because it's hard to see the picture on the screen from where I sit, but looking at, we look at which EU member states are responsible for most of these green trademarks. And of course, you will see there that it's not surprising that it's the big countries that generate the most. So with Germany in first place, which again is not surprising. Almost any measure you take, Germany will always be in the first place for the simple reason that it's the biggest country in the EU by some distance. We also get quite a few of these green trademarks from outside the EU. And here the most important country by far is China, followed by the US and the UK, and then you have some smaller countries and the rest of the world. And finally, on this chart, we look at to what degree do different countries focus on green trademarks. So what the bar shows you is the percentage of trademarks filed by applicants from each country that are in the green trademark category. So what we see, for example, is that in first place we have Switzerland, with about 22% of all EU trademarks filed by Swiss companies falling into the green category. On this chart, you see the dark blue bar is the EU average. The light blue bars are the different EU member states. So we have Slovenia in second place, actually quite surprising. And then we have some important non-EU countries, such as China and Switzerland, that are also near the top. So again, it's important to look at it in relative terms. So certainly some countries focus more on these green trademarks than do other countries. So this was my last slide, and I think I just made it in the allotted time. Do we take questions now or later? Well, now, okay, so I'll be happy to take any questions. I will put on my headset in case somebody asks me a question in Portuguese, which I don't speak, unfortunately. Thank you very much.
Thank you very much, Nathan, for your very interesting presentation about green trademarks. Yes, indeed, we will now open the floor for questions, for which we switch back to Mariano, the leader of Alimbes Verde DPI, who will coordinate the Q&A session. Mariano, the floor is yours.
Yes, thank you very much, Nathan, for that very clear presentation, and Martis. We are taking the questions in the chat. In the meantime, I want to ask you, Nathan, a couple of questions. One, they are both interrelated, actually, I would say. But you talked about a share of green trademarks in the, let's say, the total applications of EU IPO. What do you think, and that this share is growing? What do you think this represents in terms of, what does this mean what should we interpret from this? Or could we interpret this?
Sure. The way I interpret it, and I think most others, is simply the fact that, we all know that climate change and other environmental problems are higher and higher on the agenda, on the political agenda. But not only on the political agenda, they're also higher and higher on the business agenda. So consumers demand increasingly products and services that are related to let's say, saving the planet, to use a very big word, right? I mean, sometimes the consumer demand is spurred by government mandates. Sometimes it arises spontaneously, but if we look at, for example, electric cars, it's a mix of both, right? I mean, there are people who have been buying electric cars already for some years because they like the idea that they are not contributing to global warming with their driving. And then in more recent years, and certainly we can expect in the future, we will have less and less choice. I mean, there are rules in various countries that as from 2030 or 2035 or 2040, only new electric cars will be sold, right? So for whatever reason, people, consumers and businesses are demanding products and services that fall in this kind of category. And of course, business responds to that, as evidenced by the rise in patents in the relevant technology categories, and also the rise in trademarks in the relevant categories.
Perfect. Thank you very much indeed. This reflects that there is both a need and, I think, an opportunity in these markets for niche products. But and I pass to there is another question, but I think it's for literally speaking, it would be for later on in the sessions. But I'll try to relate it to something that you have presented, Nathan. Carlos Ardizone asked what if EU IPO, or what criteria EU IPO uses to avoid trademarks that might involve greenwashing practices. Okay, and then the question goes further on. But regarding, I think that's more of a question that maybe our examiners could, in Monica and maybe.
But I can make a comment on that also.
Okay,
Mariano,
good.
Because
Yes, please go ahead. Go ahead.
So when we were first planning this study, what I showed you today was actually the second edition of the study. We did the first one a year earlier. We thought about this definition of what is a green trademark, and our very initial idea was actually to look at the name of the trademark itself, to the denomination of the trademark, to see if we could somehow identify trademarks that claim to be green. But precisely because of the issue that you mentioned, greenwashing, we gave up on it because it's clear that some companies, because consumers demand green products, just to use a short expression, some companies mislead consumers actually by branding their products in a way that suggests that they are good for the environment even when they are not. This is precisely why in carrying out this study, we did not look at all at the trademark itself. We only looked at the goods and services specification of that trademark to see whether they relate to the relevant categories that we had predefined. This is exactly to avoid the greenwashing issue.
Okay, perfect. And then using this question to go a little further on this very present topic, you talked about an algorithm before for which should assist in let's say sorting out green trademarks, and there is legislation which is emerging on greenwashing. There's a proposal for directive, and probably now it's not exactly clear what greenwashing is, let's say, narrowing it down to a very, very precise point, but probably if it's written in law, it would be easier. Would an algorithm that sorts out green trademarks take legislation into account?
Yes, of course. In principle, I mean, in principle, it could. Yes, I mean, again, without knowing the details of the proposed legislation, well, we really don't because it's not been adopted yet. So, but yes, so it would involve, of course, looking at. I mean, the legislation will, of course, address the issue that I mentioned before. It will address the denomination itself of the trademark. So yeah, it would be complicated, but it could be done because, of course, one would have to decide what is a greenwashing, when a particular trademark is really a case of greenwashing and when it's the case of a genuinely environmentally friendly product, right? So it's not obvious, but I'm sure it could be done.
Okay, thank you very much, Nathan. Para Carlos Ardisone, vamos responder o resto da pergunta no curso do seminário.
We'll be answering the last of the questions. Thank you very much.
Nathan, you are free to participate during the whole seminar, whatever you want, but I know you are a very, very busy director, and so we thank you very much for being with us.
Well, thank you for inviting me. And just as a little anecdote, I have a Brazilian daughter-in-law, so I have a connection to your country that goes a bit beyond the purely professional. Thank you.
Thank you very much, Nathan, and Mariano as well for this Q&A session, and Nathan for your presentation. We will now proceed with the second session of today's workshop, to which I'm very happy to announce that over 200 people have registered, and also that the recordings of both today and tomorrow will be made available at the later stage on our YouTube channel. The title of the second session of today is The EU Trademarks, Best Practices, Registration Insights, and Key Case Law, which will address best practices for registration, key grounds for refusal, and the most relevant case law for Brazilian exporters, as well as tips and recommendations for Brazilian users when registering a trademark in the EU. And this presentation is given by Monika Tomczynska, team leader in the Business Operations Department at the EU IPO. Monika has been working at the EU IPO since 2011 and handles applications for individual, collective and certification EU trademarks, as well as applications for registered community designs. Monica, welcome, and the floor is yours.
Thank you very much, Martis. Thank you all for being here. It's a pleasure for me to be able to present this topic at this conference. Sadly, I have no connection with Brazil, but I would definitely love to visit your country. Okay, so let me start. Here you can see the agenda of today's presentation. So I would briefly introduce the European Union, the European Union Intellectual Property Office, and the European Union trademarks. I will talk also about the process of filing, examination and registration process, some resources which I think will be very useful for you in your daily business, let's say, while dealing with IP rights at the EU IPO. I will discuss absolute grounds for refusal, so I hope I will also reply to the last question, at least in some part, concerning the misleading or deceptive character that the trademark may have. And here, yes, actually, this will be the part on the case law, and I will finalize with some takeouts. So, as you can see here on the slide, this is the map of the European Union, which is a political and economic union of 27 member states. So, as you can see on the screen, it covers the vast majority of the European continent. The whole European Union has an internal single market. What does this mean? This means that within the borders of the European Union, there is a free movement of goods, services, capital, and people. So I think it's an opportunity for you in case you would like to protect your rights with us. So here also on the bottom of the slide, you can see where we are. We are in Spain, in Alicante. Our name, as I said, is European Union Intellectual Property Office, and it's one of the agencies assuring the good functioning of the European Union. As our name indicates, we deal with intellectual property rights, some of them mainly European Union trademarks, designs. We are also involved in the examination of geographical indication for foodstuffs and drinks. And in the coming years, we will also deal with the geographical indication for craft and industrial products. Yeah, you can also see on the slide that actually this year is a very special year for us because we are celebrating our 30th anniversary, and to date, we registered already 2.6 million trademarks. On the next slide, you can see a bit the idea of the protection in the single market. So as said, if your application is successful, it will have protection in all the member states, the 27 countries, so almost in all the territory of Europe. It's an optimal choice in this case because you don't have to know the procedures of the different national offices, the payments don't have to be done in different currencies. So the EU IPO system is a centralized mechanism. It is obviously complementary to the national and more global protection, like here I mean the WIPO system, which I believe a representative of your national office will talk after my presentation. So the process is very simple. It is one application in one of the European Union languages. There is one fee. You can see on the slide the basic fee and the subsequent fees for the different classes. The more classes you apply for, the higher is the fee. And there is a reduction, which I will talk about in the next slide. And if everything is okay, then you have the full protection. And as said, it can be also a pathway to more international protection. So here you can see, I will now I will go to the process of filing, to the next point of my presentation. So actually there are two ways of filing an application for a European Union trademark. One is the e-filing, so electronic filing, and the other one is by postal courier. Obviously, due to the distance, I don't think that you will use the second one. And there is also a very good second reason not to do that, is because the basic fee for a trademark application is reduced to 850 euros from 1,000 euros. And here on the slide under e-filing, you can see also two possibilities which you have. One of them is the so-called fast track, and the other one is regular track. What are the benefits of fast track? It is in case you fulfill some conditions, which you can see now on the slide. Mainly, you have to apply, obviously, online. For an individual mark, you have to choose maximum 300 terms from the harmonized database of pre-approved terms, about which Nathan already spoke briefly. And you have to pay within certain time limits. And obviously, the examination of your application has to be successful. In such case, your application can actually be published within some days. Our maximum time for fast track publication is 20 working days. Nevertheless, it can be even quicker. So here I show you also the logo of the TM class, which is database which is linked both to the NIST classification and also to the harmonized database that Nathan was mentioning. On my next slide, I will show you that within the e-filing, there are also two more possibilities of filing your application. One is called the EUTM Easy Filing, which is a very easy tool which guides you through the application process. Nevertheless, I think which is important for you as coming from outside the European Union is the EUTM filing. The EUTM filing has the possibility to appoint a representative, which I will talk about later on, which is a point which you should take into account. And also you can there indicate within the application filing process, in case you have a priority, so you filed already for an application in Brazil, in your national office, if you do it within the period of 6 months and you indicate it at the point of filing an application, you can claim priority of your earlier Brazilian right at the EU IPO. This serves mainly in inter partes proceedings in case there is any conflict with other right, that the date of start of the EUTM European Union trademark application does not count from the date when you filed it with us, with the EU IPO, but it counts as of the filing of your Brazilian application. So here in this slide, you can see the line, how examination is done. So at the first part, you can see the examination process. It starts obviously with the filing of your application. What we do here is we examine the filing date requirements, which, to be honest, probably you will comply with the majority of them if you file via the e-filing form. Then we do more or less at the same time the examination of formalities, classification of goods and services requirements, and also the absolute grounds for refusal. If everything is okay, the mark goes to publication. And I will talk about the part about what happens after publication at a later stage. So here you can see the filing date requirements, which are listed on the slide. So obviously there has to be clear request for a trademark at the EU. You have to be identified as the applicant. There must be clear representation of the trademark you are applying for. There must be accompanied by a list of goods and services, and the application has to be paid. At the EU IPO, the examination process starts once we received the payment. Another point I would like to highlight here is that while you are filing for the application, you have to obviously identify yourself as in case you are applicant. You have to provide your legal form, the name, personal name, or the name of the company, and a full address. What is relevant for you coming from outside the European Economic Area, that either if you don't have a representative in your country or you have a legal advisor who's helping you, in order to be able, for your mark to be able to be examined at the EU IPO, you will need a representative who can act within the area of the economic European area. So this is a requirement for parties without a domicile, principal place of business, or a significant industrial or commercial establishment outside the EEA, so the economic area. What I can tell you is that you can find a list of these representatives who can act before the EU IPO on our website in another tool which is called eSearch Plus. I will talk about it briefly afterwards. And please also remember that the application has to be signed with name and surname of the person who's filing or the representative. So now I would briefly talk about the different kinds and types of marks which we accept here at the EU IPO. There you can see the three kinds of marks. I will concentrate on the first kind, on individual marks, because some presentations later, my colleague Hugh will talk about collective and certification marks. Concerning the type of marks, well, I think the word mark is self-explanatory, the shape mark also, and position. As regards the figurative marks, at the EU IPO, we accept either marks which you can see at the presentation right now. I'm sorry, it was not yet visible. So either it can be stylized words, or it can be a purely figurative element, or a combination of both. Another option is that in case you file, for example, in Chinese or Japanese characters, this would also be considered a figurative mark. There are more possibilities of filing different types of marks. And with the legal reform we had several years ago, we established also new types of marks, like, for example, the multimedia or hologram marks. So for this marks like sound mark, motion, multimedia, hologram, then you have a possibility to file them not only like a visual graphical representation. You can, for example, send an MP3 file. The technical requirements are also on the EU IPO website. It's one of our executive director's decisions about communications by electronic means. Another aspect to take into consideration is that you have to choose 2 languages while filing for an application. The first language can be any of the 23 languages of the European Union. So, for example, Portuguese could be perfectly valid as a language of your application, the first language. The second language has to be chosen from the 5 official languages of the European Union. Intellectual Property Office, which is English, Spanish, French, German, or Italian. Why we require the second language? This is for inter partes procedures. Hopefully you will not have such situation, but in case someone oppose your mark, then the second language is for these proceedings. And obviously about goods and services, I think there is not so much to say, so I will briefly explain that obviously we are based on the NIST classification of goods and services. We have our harmonized database, which with other offices, which can also be seen in the TM class tool. Available online on our website and on different platforms, which anyone can access. So here, obviously, the scope has to be fully understood, clear, precise, and the classification is done according to the function or purpose of the goods or services. Here you have some, it's not an exhaustive list, but it's a list of resources that are available both to you, and I can also assure you that we, the examiners, are also using them in our daily life. So obviously we are bound by the European trademark regulations, and based on them, the office developed guidelines which are practical indications based on the regulations, on the updates of the NIST classification, and also on the recent case law. We also use different tools like TM Class, which I talked about, the eSearch Plus. We have a tool called eSearch Case Law to look for the established case law, GI View for geographical indications. We also use some other databases like the IN for medical stamps in class 5 for medical products, Sexter, which is a list of the flags and symbols that cannot be used in as such or imitated in the trademark representation. So for example, Brazilian flag could be objected based on absolute grounds in case it is part of the representation of a trademark. We are also checking the CPVO database, which is for plant varieties. And we use the tools which all of us are in general using every day. So internet searches, encyclopedias, dictionaries, acronym finder. As said, this is not an exhaustive list. So now I will talk briefly about more resources that we have. And again, both the examiners and also general public can use them. I did the screenshot for this presentation so that you can see that our website is available in the 23 languages. So here you have the Portuguese version. And I talked already about TM Class. We also have TM View, which we use to search for trademarks of participating official trademark offices at national and international level. So for example, in case you file for a priority of your mark in Brazil, we can find this information in TM View. Both in TM View and in eSearch Plus, you can search by image, not only by words, but also by image. eSearch Plus is information about trademarks, designs, representatives, and bulletins of the European Union Intellectual Property Office. So, for example, there you can find a representative who could represent you before the EU IPO. I will talk about eSearch Case Law a little bit later. And what I would like to highlight that all these databases are available all the time, free of charge for everyone. Here is a screenshot where you can find also the guidelines of the EU IPO. They are updated on a regularly basis. You can see the different versions. You can even see what has changed from one version to another, because there you can find the changes in track changes. Also, the guidelines are available in the 23 languages of the office. So you can also find them in Portuguese or Spanish or Polish, which is my case as I come from Poland. Now I will talk about the absolute grounds for refusal. These are the reasons why a trademark cannot be registered because of considerations related to the public interest. So on this first slide, you see the first two absolute grounds for refusal are the most common, obviously. It's in case when the mark is considered descriptive and lacking distinctive character. The list I will show you is not an exhaustive list, but the exhaustive list you can find in our regulations, and also each of them is explained with examples in the guidelines. So what is also important here, that if a mark is considered descriptive in one language of the European Union, as I said that the trademark has a unitary character, either you get the registration for all the European Union, or your mark will be objected to. So for example, if a mark is descriptive in Polish, you will be receiving an objection letter, and for every objections you will receive, you will have 2 months to reply. This is a general rule in all the proceedings, or at least in the majority of the proceedings. There are some which is 1 month. So the 3 grounds you can see here together, so the descriptiveness, lack of distinctiveness, and the customer, in case the mark became customary, could be overcome by filing a request stating that your mark has acquired distinctiveness through use. In such case, you will be asked to provide evidence for all the goods and services and for all the territories in which it has been considered that your mark is either descriptive, lacks distinctive character, or became generic. Here there is the list of the other grounds for refusal, absolute grounds for refusal. The first one is related to shape marks, then trademarks contrary to public policy and principles of morality, then the deceptive character, and trademarks in conflict with flags and symbols. As I talked before, this is related to the sexter, the flags, and heraldic symbols. And finally, we also examine marks in case we check if they are in conflict with maybe a geographical indication, some protected terms or food, drink, craft, or plant variety denominations. From all the resources that are available, both to the examiners or to you, I would also highlight this one, which is the convergence of practices. What does it mean? It means that the European Union intellectual property, together with the national offices of the member states of the European Union, they decide on a topic they would like to develop a common practice. And here you have a screenshot from part of the common practice number 3, which was about marks combining verbal and figurative elements. So I think it illustrates quite nicely from going from red, from marks which will be considered descriptive and lacking distinctive character, more towards the green part, which would be more likely to be accepted by the participating offices in this project. All these common practices, this one and many more, are also available online for everyone. So now coming to the case law, as here we are talking about green sustainability and in general about eco-related topics, I have chosen some case law related to this. So for example, you can see that a mark which contains the word eco, we will understand it as ecological. Green would be understood at the EU IPO as environmentally friendly. So in this case, if the mark has no other distinctive element, it can face an objection. Here I have another example, which I don't know if we can open the floor for any participant to say something, but what do you think about this mark, biomarked? Would you accept it? Do you think that the court accepted it or it refused it?
Perhaps
Yes. In the chat or hands up? We have any reaction? Or people are shy?
It looks a bit lacking a bit. Is it a figure mark or is it just a name, Monica?
The figurative mark, the biomarked.
What does our audience think? Is this distinctive?
Your services, please, excuse me.
Yes, I'm sorry. True. That was cosmetic products in class 3, medical preparations, and also foodstuff and drinks. And retail, obviously, and selling of them.
Pode adivinhar, Carlos, também. Mas...
It's 50-50.
Thinking as a Brazilian examiner, I would not find a problem to grant this trademark. No.
Okay, thank you very much for at least one brave participant who wanted to share his view. Well, actually, the European Union Intellectual Property Office and the court confirmed the decision. This mark has been refused. Why? Because marked and also bio can be understood in German. So already the mark has a certain meaning. That's why I'm always saying about the unitary character. Also, the court highlighted, well, they talked about, that's why I indicate here the paragraphs, which you can read the decision. Actually, on our website, it is translated. So if you go to eSearch Plus, even if the mark is in German, it will be translated in several languages, like at least in English, French. So even though it was a neologism, the office and then the court confirmed that it will be easily understood, at least by part of the public of the European Union. And also the use of colors will even reinforce the message. So green and brown are normally related to something like food stuff or crops, etc. Something also green ecological. And the figurative element, it resembles leaves. So all these figurative parts are reinforcing the message. So these three examples here would not be acceptable. But in any case, you can check our databases to see also the threshold and guidelines to see the threshold for acceptance of marks.
Monica, one if I can,
yes.
if I just reinforce what you mentioned, that of course these considerations in the European Union would have to deal with multiple languages and multiple markets, which probably maybe biomarked in Portuguese will not be as let's say close to descriptiveness as it would be in German, right? I think this is a good takeaway.
Yes, but that's why I mentioned in my previous slide that, thank you, Mariano, the use of dictionaries, the guidelines, because there are many, many resources that you can use to double check the mark. Now concerning, I will be like a bit negative here in my presentation, but I just want to show you those examples when there can be something can go wrong. But obviously with 2,600,000 marks, the majority or many of them are being registered. So here I just only highlight some cases. This case has been refused for being descriptive, and obviously when mark is descriptive, it's also non-distinctive. It lacks distinctive character for goods related to electrical energy, distribution of energy, heating related to renewable sources. But there was in the quite long list of goods and services one term, which was electrical energy from non-renewable sources. And this one term has been objected to as being deceptive. That's what we were talking, maybe it links nicely with the question about greenwashing. No, this mark being green power technologies would deceive the public if it's used for this term in class 4. Here, another example. Finally, I found mainly German examples. This one was a certification mark, and what it reads here, the ohne Gentechnik hergestellt. This means produced without genetic engineering. So the mark as such was okay. It's quite descriptive and non-distinctive per se for goods in class 29, 30, 31, 33, 5. So I mean here foodstuffs, drinks, some medical preparations, and unprocessed plants, etc. But in this case, and I think Hugh will develop further on this, in certification marks, we don't only check the representation and its relation with goods and services. We also require the applicants to file for regulations of use. So here, why we considered this mark as being misleading? Because the mark as such says one thing, that all this is produced without genetic intervention, but actually within the regulations of use explaining the certification mark, it was stated at some point that this mark will allow a certain percentage of genetically modified ingredients. Now I would talk, because actually we don't have much more time to show you the examples, but what I would like to invite you is to check the database eSearch case law, which again is free of charge, available to everyone. And you can either search by the number of the case, but I think it's easier to search for a particular word or expression. But in case you would like to do more exhaustive search, you can here click on advanced options, and you can check, for example, if you only want to see what deceptive marks have been refused, or I don't know, containing a flag. So you can do more detailed search. In this case, by language, by text, if it's a decision of the boards of appeal or maybe a court decision, etc., etc. And also, if you're interested in the recent developments of the case law, you can go to these two sections, the recent decisions of the boards of appeal and the judgment of the courts. I also would invite you to check our website for the learning portal. It is also full of very interesting webinars. We have our Tuesday webinars. There are some courses of different levels of difficulty, let's say. So some basic courses and some very detailed trainings. So coming to the end, let's say that everything went smooth, everything went fine, your trademark has been positively examined, and it has been published. What happens now? It's the opposition period starts. At the UIPO, the opposition period is 3 months, and it cannot be neither shortened nor extended. This is for third parties to file an opposition in case they consider your mark is in conflict with their earlier right. So if such a position is filed, the parties are giving time to settle down, 2 initial months, which is the so-called cooling off period, which may be extended, up to the total of 24 months if both parties submit such request. Further extensions are also possible, and also suspensions. So there you can either settle amicably. You can, for example, if you are opposed, you can also file for a restriction of your list of goods and services. And in case you do so, then you have 2 months in order to give the opponent time to withdraw the opposition. There is another tool in which you can check if your goods and services are maybe in conflict with others, and this is the similarity tool. So as you can see, there are really plenty of tools to check if there are some similar area rights, at what point they could be considered similar. We at the UIPO check if the similarity is at visual, oral, and conceptual level. So if there is no opposition or you solved the conflict, then your mark is registered. It is registered for 10 years, but actually it can be renewed forever. So your mark can be living forever and ever. And also here I would highlight 2 more things. In case at any stage, both examination or opposition, you disagree with any of the decisions of the office, you can file an appeal to the boards of appeal. And there you have what is called the ADR, so Alternative Dispute Resolution, especially for inter-parties. The Boards of Appeal has these tools for the parties to come to an agreement, like there is a mediation. So also at any stage, what you can do is you file for a change of name of the owner, or transfer of the mark, license, rights in rem, etc., etc. And once your mark is registered, you have also right to protect it against others. So you can file yourself an opposition. You can also request cancellation of a right. There are different options. So to finalize my presentation, what I would like to highlight here, that the European Union trademark system is centralized, very easy, one filing, one fee in one currency, and it gives you unitary protection for the whole single internal market of the European Union. The process of filing is very easy, fast, and it is not really expensive, taking into account that the protection is for 27 countries. What you would have to remember is that you would need to appoint a representative who can act before the EU IPO. And the trademark can be published if it complies with all the requirements within really some days. And there are plenty of resources to check. So our website, there are different databases, there is the learning portal, all are free of charge and for you to use. And in case you still have any questions, please do not hesitate to contact us. So thank you very much. That was my presentation.
Thank you very much, Monica, for your very interesting presentation about EU trademarks. And indeed, we now open the floor for any questions you might have, for which we switch back to Mariano, please, who will coordinate a Q&A session. Mariano.
Thank you very much. Muito obrigado. Temos aqui uma pergunta que eu
Thank you
vou
very much. We have here a question that I will say in Portuguese, and I hope that Monica can hear the interpretation into English by our colleagues, the interpreters. Okay. So here's the question. If a requester was compliant when it filed the request before UIPO, the requirements for green sustainability, but then at a later point becomes non-compliant after the mark is already registered in and in force, can it be challenged by UIPO due to overbearing deceptiveness, since it's no longer related to the initial sustainability idea that it got a grant for, or a mark for, or is that an issue for the courts?
Então.
Okay, thank you very much for the question. Actually, I was awaiting it. So what happens here is that we are bound, as Nathan was saying, by the regulations. And the regulations do not really foresee that double check what happens with the marks once they are registered. But that's why we have different options for the third parties. So actually, I can here mention that even a third party can file an observation during the examination process if they consider something may be deceptive or misleading. And also we have in place the cancellation proceedings. So there can be an invalidity of revocation, for example, in case something like that is detected. Like one of the grounds for that is bad faith, for example, or that really the mark is misleading. It's not used as it was applied for. No? So, for example, a mark which is totally for renewable energy, and out of sudden they change their business, the company changes their business model, and they do everything with non-renewable sources. So for this, the office only examines when there are post-registration actions filed by third parties. I hope this replied to your question.
I think it did, at least from my perspective. There's also a question from Patricia Barbosa from INPI. I will read it in Portuguese, okay? No caso específico das marcas de certificação.
Specifically talking about certification marks, specifically for certification mark, is there any new sort of examination or proof that the rules are being followed when there's an application for a renewal of the mark? Is there any re-examination done?
Just to mention, Patrícia, vamos ter uma sessão específica
Just so
para
you know,
marcas
Patricia,
de
we're going to have a
certificação,
specific session on
no
certification
final
marks,
hoje.
by the way, at the end of the session
Mas
today.
deixe também
But
a
yes,
pergunta
I
para
also leave your question for Monica.
Well, maybe I can, just in case, actually the next speaker is here already, so maybe you can ask him, but to be honest, the certification mark is quite new kind of mark, which entered just recently into force, so we are not yet having this renewals, because the reform was 2016-2017. So it's not yet, first of all, but we do the examination when we receive the application. So we examine the regulations of use in case we find any discrepancy. But then again, we rely on third parties' observations, and this is rather regulated by the market at a later stage. But I believe Hugh, who will be talking a little bit later, can maybe shed a bit more light on this topic.
Okay, thank you very much. I think, Martis, you are keeping the time, but I think we should pass for the next presentations. Is it like this?
Indeed. Okay, well, thank you very much, Monica, for your presentation. We'll be hearing more from you throughout these 2 days.
Exactly. And thank you very much. Have a nice day, nice afternoon, and see you tomorrow.
Thank you, Monica. Chegamos agora à sessão 3,
Now we've
intitulada
got to session 3, which is about guidance on using the international registration system in place in Brazil. We'll be guiding insights, practical insights, to use the international registration system in Brazil. The practical ideas and guidelines from the National Institute of Intellectual Property in Brazil. Felipe Coutinho de Castro will be sharing his insights with us. He's a technologist in industrial property of Brazil office, and he's also member of the work group for the Brazil regarding the Madrid Protocol. And now he's the leader, the head of technical exam and in the office, designated office. Felipe, you have the floor. Good morning. I hope you can listen to me. I'm going to be speaking in Portuguese because I do believe that's more interesting to our Brazilian users that might be interested in focusing in foreign markets, specifically, namely the European Union, as we have been highlighting.
Bom, acho que vocês estão vendo aqui, né, a apresentação.
Can you see my presentation? Is it on the screen? I'm going to introduce you to the use of this international registration of marks abroad. Brazilian marks that want to file patents abroad. So we do have 3 ways of approaching foreign markets, and we have the national way,
Depositar sua marca, a rota regional, que foi falada pela colega Mônica anteriormente, que seria a EUIPO, a UAP e outras instituições regionais, e a rota internacional, que é o Sistema de Madrid. Então, é sobre esse que a gente vai falar um pouquinho hoje. O Tratado de Madrid, o Protocolo de Madrid é um tratado internacional multilateral por adesão, né? Ele faz parte do Sistema de Madrid, que contém o Acordo de Madrid e o Protocolo. O Brasil é signatário só do Protocolo. Já foi signatário do Acordo no passado, mas hoje em dia não é mais. E o sistema de Madrid tem o objetivo de facilitar o registro em muitos países, né, em vários países, que são os países membros. Aqui um breve histórico: o Acordo de Madrid ele é de 1891, o Brasil foi signatário em 1896, mas ele denunciou esse acordo em 1934. Hoje em dia, todos os membros do Acordo de Madrid são membros também do protocolo, então o protocolo prevalece e o Acordo de Madrid está congelado desde 2016. Aí, o Protocolo de Madrid, o qual o Brasil é membro, ele é mais flexível do que o Acordo de Madrid. Ele hoje conta com 115 membros, que abrangem 131 países, o que dá mais ou menos 80% do comércio mundial. Ele está em vigor desde 96, o Brasil é signatário desde 2019. Ele é o único passível de adesão, já que o Acordo de Madrid está congelado. Essa é a abrangência geográfica do protocolo, né, de todo o sistema de Madrid. Vocês podem notar que a América Latina é uma parte do mundo onde tem poucos integrantes ainda no protocolo, mas acredito que a OMP esteja trabalhando para que mais países façam a adesão. Quais são as vantagens do sistema de Madrid? Ele possui um registro único, contendo informações de todos os registros pelo mundo. Ele pode ser, se usa apenas um idioma, inglês, espanhol ou francês. O Brasil, como escritório de origem, aceita inglês ou espanhol. Você tem uma única data de prorrogação em todos esses países, então você não precisa ficar prorrogando em datas diferentes em cada um dos países que você tem a proteção. Você faz isso uma vez só. Você utiliza uma moeda só, que é o franco suíço. Dispensa a necessidade de constituição de procurador nacional, salvo em casos que você tenha recusa e precise responder algo diretamente ao escritório designado. Possibilita designações subsequentes, que é quando você já tem um registro que quer adicionar outros países, e possui um prazo de resposta dos países designados. Os países têm até 18 meses para dar uma primeira resposta para a sua solicitação. Isso não significa que o processo vai ser finalizado em 18
So
meses,
it's going to be finalized up to 18 months.
Projeto brasileiro, a gente tentou aderir em 2002, em 2008.
Brazil tried to become a member on different occasions, but that didn't go well. And then we got back to this project because it was part of the plan of undoing red tape procedures that's in the Industry and Commerce Ministry in Brazil. So it will be 5 years next week. That's the anniversary of this admission. And then I'm going to tell you how our office works. We, as an origin office, the INPE, it certifies the international request, international filing. Then it is transmitted. The international request is transmitted to the WIPO, and then we have the monitoring of that period. We can use English or Spanish, and the detailed procedures are registered as well. So, in a very brief manner, how could we carry out the international request, the international file, and we have to certify. So first, there is the filing for the national mark, and then the holder files for the certification of the INPE. And then the other steps. There are other steps for the international requests. They can only be done through the intellectual property offices, and the holder must fulfill the requirements for this filing. When you have to fulfill at least one of the three: the domicile, the effective commercial in the country, the effective effective commercial
domiciliado nesse
establishment in the country,
ou
or
ter
at least they should
estabelecimento
live there.
industrial ou comercial
Or
efetivo
the
nesse país.
industry
qualquer
must
dessas
have
três,
headquarters or at least an office there.
qualquer
If
desses três
any,
requisitos
if
forem
the,
cumpridos,
those
ele
three
pode
requirements,
utilizar
each,
o sistema
any
de
one
Madrid
of
a
that
partir do
three
país membro,
is
caso elas
fulfilled,
sejam.
then they can
É necessário ter um pedido
present
ou
their
registro de
international
base nacional,
filing,
ou
and
seja,
then we
tem que
have
ter
the
pedido ou registro
you
já no
have
INPI,
to
que vai ser o pedido básico que será utilizado
choose to
para o
show
pedido
the
internacional.
requirement, the base registration for your country, for the country of
O
the
escopo de proteção
the
ele tem
mark,
que
and
estar
then
contido
we
nesse
have the
pedido de base,
protection
não, você não
scope
pode
that
pedir
must be
mais do que você já tem nos
contained
países
on
de
that
origem.
request. You
O
cannot
INPI ele
ask
tem
for
2 meses
more
para
than what you
certificar
have, then
esse pedido
the
a partir do
applicant
momento que ele
must
chega.
do
Se
that.
o INPI conseguir certificar, se não
And
tiver
then, if you
evidências, se não
have
tiver
this
problema,
certification, if
o
there is no
INPI
objection and
certificar esse
so on,
pedido
so if the
em até 2
INPI
meses do protocolo,
certifies it up to 2
ele
months
vai ter
later,
o pedido internacional terá a
you
data
have
desse pedido de
the
certificação.
applicant will have
Caso,
the
contrário,
certification
né, a
date
parte tenha alguma
for
exigência, alguma coisa
its
que não seja possível
application.
certificar
If
em
it's
até 2
if it
meses,
doesn't
a
happen, if
data do
2
pedido
months go
internacional vai
by
ser a
and you
data que a
don't have
Secretaria
it, the
Internacional da ONU
international
recebeu esse
request
pedido.
date
O
will
INPI
be
não faz
the date
alterações
in
nesse
which
pedido de
WIPO
certificação, então
gets the
caso tenha, não
process.
faz alterações de ofício.
So
Então, caso tenha
the
alguma
Brazilian
deficiência ou alguma
office
irregularidade,
cannot
é
carry out
necessário que o
the
titular
alterations we
apresente
were
novamente
discussing, so the
formulário
holder must
N2.
come back with the
Tem aqui
N2 form.
esquema pouquinho mais
So
detalhado de como é
here we
feito,
have a
né?
more detailed, it's
Esse
a
serviço tem
graph that
custo, esse serviço de
details
certificação, ele
the
custa
phases of this
R$ 406
process
por
of
FAR,
Brazil as
né?
an
Então, esse
OO,
pedido
as
por
an
FAR,
origin
você vai ter que multiplicar
office,
esse valor pela quantidade
and
de
we
FAR
can
que você
multiply, so
tem.
we have the values
E o trâmite é muito parecido com todos os
and
outros trâmites que a gente
the
tem aqui no
the
INPI, né? Você vai ter
phases
que
are very
gerar uma
similar.
GBU,
So
pagar
the
a CVMI,
processes
preencher
and the
formulário
requirements
eletrônico.
are very
Esse
similar to
formulário
the ones
eletrônico é
we
preenchido
carry
em
out
inglês ou
in
espanhol.
INPE. We have to use English
Inclusive,
or
a
Spanish,
especificação de produtos ou
and the
serviços tem que
specification,
ser
product
traduzida para inglês e
specifications
espanhol.
must be
Nós aqui
translated
no
into
INPI vamos
English or
certificar
Spanish. We will
esse pedido,
certify
né?
in
E
our
se tiver tudo certo,
office
a gente
that
transmite
request,
para a
and
Secretaria
everything
Internacional,
is
que vai lá fazer
correct,
essa
we'll send it
verificação
to
e
the
também, se tiver
International
tudo certo,
Secretariat,
ele
to the
recebe um
international
número de pedido
organization
internacional
that will
e
carry
com esse
out its
número
own
ele
process
é
of
distribuído para os países que o
examination, and
titular
then
optou
it will be
por solicitar
distributed to
proteção.
the countries to which the
Os
applicant
requisitos
has
básicos de
filed for
certificação
protection.
são a lista de
So
produtos
we
CNIS,
have
né? Tem
the
que estar
list
lá
of
descrita em
goods and
inglês e espanhol
services
e
that
tem que
must
estar
be
contida no escopo
in
de
English and
base, não pode
Spanish,
estar
and
para
it
além do
must
que você já
be
tem aqui no
inside
pedido do
the
INPI.
the
É
request,
necessário que a titularidade
and the
do
holder
pedido de certificação, né, do pedido
must of the
internacional e o
certification
pedido de base sejam idênticos
application
para
must be
certificar que é da mesma
identical,
pessoa.
so
O
that you
número e
can
as datas dos
com
pedidos de base,
confirm that's the
a
same
imagem da
person or
marca,
the
que
same
deve ser
company
igual
that
também
is
ao do pedido de
applying
base,
for this
natureza,
registration,
características das marcas,
and
se é uma marca
also the
coletiva, se é uma
mark
certificação, se é
features, if it's a collective mark, if it's
ou seja, tudo isso
certification,
tem
if
que
it's an
estar
active
também
mark, so
descrito
on and so
no
forth.
formulário.
Everything must
E
be
caso tenham cores
included
indicadas,
in
as
the
cores têm que ser
form.
iguais
And if there are
às
some
que
colors
determinam
that
indicando o
are
pedido.
defined, they must be the same
A
colors
maioria das
from the
irregularidades que a gente
other
tem com relação ao pedido de
registration
certificação diz respeito ao
application.
trânsito,
So there's some
seja
irregularities that
na
come up
tradução
more often, and
transportuária,
most
seja
of
que
them
o escopo de
that
proteção está
occur
mais
during
abrangente do
certification,
que o
they
pedido
have to
base,
do,
nesse caso a
usually
gente
they
não
have to
pode
do with
aceitar.
goods and
Então, nesse
services
caso, são feitas
not being
irregularidades
included
publicadas no
on
INPI
the
e o
request,
usuário
on
tem que
the
cumprir também
basic
no
application.
formulário, que ele
So
pode
we have to make it clear at the
esse cumprimento
form
custa
that the holders
R$ 330.
must translate their specifications
O INPI, de fato,
of the
solicita que
specifications
o
of
usuário
goods and
traduza, porque a gente não pode
services. The
fazer essas
user is the one
alterações
that
de
must
ofício.
carry out that
Então,
operation, the task, so to speak.
e esse procedimento pode gerar alguns erros que também
And
podem gerar
this
algum
procedure
pedido de
must
esclarecimento ou
sometimes
irregularidade.
it causes some errors that can be corrected. But besides that, there's some irregularities that come up due to formalities, for instance, different addresses, the name of the holder is different on the application, on the first application. So we ask the holder or to correct those details. And once everything is corrected and compliant, we'll send it to the International Secretariat, who will carry out a formal examination. If there are irregularities, they will be notified. So the applicant or the institute must answer to those notifications. So sometimes they consider the specifications to be too vague, for instance. So they have to specify what they're talking about, and the applicant is going to answer through our office, through the Brazilian Institute. And it must be proven that it's within the scope. The deadline is 3 months that's what the National Secretariat demands for the applicant arguments. And if the user or the applicant does not agree, or if the office does not agree with the WIPO classification, the final word is always WIPO. So if there is not an agreement, the WIPO decision is the one that will be applied. And once you do that, we get to the international register with subsequent designations. How you can see here how to pay for the process. You do that in Swiss francs. So besides the countries, every country will have to pay in Swiss francs, and there are 4 ways of paying for it that are accepted. You can do a wire transfer for the WIPO account, or you can do use a credit card. That's a little bit more complicated because you can only use it if there is a number of international certification number. And so maybe that could get in the way of the swiftness of the process, because there'll be, if there is no payment acknowledged, you won't be able to go through with the process. And there's another possibility, it's the so-called postal wire, but that's only for European residents. And then we have this dependence period in which it will be binding for 5 years for the register. And what does it mean then? Well, it means that if there is any change that will alter the protection scope, that will be affecting your international application as well. So if it's out of date, or if you have given up on part of the protection, anything that might have happened during that period that will interfere with your international application. So if it's expired, or if the international application will also be considered expired, and then it will no longer exist. That might happen also because of an objection, because any other process that might take place. But in the case it happens, the user, the holder, might require the change, they might require to change from an international application to a national application, and so the holder or the applicant might do that on different countries. That's a way of protecting him or herself against the objection or of the international application. Here we have the general coordination for the Madrid Protocol and for other international treaties that we deal with. So we have the general coordinator, we have 2 heads of division and 9 examiners, and also we have a technical support that works for us. Within the 9 examiners, we have 3 of them that are focused on the certification process and they send it to the International Secretariat. Now let's check some statistics, some data I'd like to share with you. And the first thing is that Brazil, as an OO, it's on the 30th position of countries that send international applications. So we are the 30th in that list to send them trademarks to other countries as an international application. So with 187 applications in 2023. We do believe that number should be growing in the future. We are going to be sending more applications internationally. Sometimes Brazil receives lots of applications, and as a receiving party, we occupy the 30th, number 13 in the list of countries that get the most applications for intellectual property. And amongst developing countries, we are on the 5th position, and we are one of the countries that send more applications to Madrid system.
A quick summary here of our work as an OO. We started in 2019 with 23 requests sent, and from then on, we kept growing. Small decline in 2022, but we've been keeping our average between 160 and 180 requests for registration per year. What are the main destinations of Brazil's request for registration of marks? Our applications have predominantly been submitted to the US first and to the EU second. 289 applications and 232 applications, respectively. In 23 alone, we sent 95 to the US and 77 to the EU. So the EU is clearly an important destination of Brazilian trademark applications. This is just a couple of screen caps of our forms. This is the NM2 International Protocol form, and the MM2 is filed by applicants whenever they request international registration. Remembering that this is the English version, but there's a Spanish one available as well.
As principais práticas e desafios de certificação e transmissão.
So what are the main practices and challenges that we've had for certification and submission? The process to certify and transmit a mark at the IPAS systems requires a large number of manual interventions, which makes the process slower and more cumbersome than we would have liked. This is also complicated because all our communications are communicated via the RPI. And this RPI is a resolution, and it has an official way of doing things. It has specific approval flows. It has specific deadlines that need to be followed. So this makes the process more morose than we would have liked. And because we have 2 months to do the transmission to the International Secretariat of the INPI, whenever there's 2 or more irregularities, it's difficult for us to comply with this 2-month deadline. We have a project now ongoing at the INPI that we call Direct Dialogue with Users. It's the ongoing name of the project. The idea is for us to start getting in touch with email directly with users who make submissions, and explain to them what they need to correct in their application, so we don't have to go back and forth multiple times with these requests for correction. Of course, usually we're still able to meet that 2-month deadline, but there is one or another proceeding that gets more complicated, and for those we fail to meet that deadline. Transmission is not fully automated. We generate a PDF, which is then transmitted, and it is sent through something called an MOP, a Material Office Portal. So what are we doing to mitigate these problems? One, we're currently doing viability studies or feasibility studies, depending on what you call them, to implement what is called e-filing, which is the electronic filing system established under the Madrid Protocol. It's a WIOP system that is WIPO, sorry. It's a WIPO system that it makes available for member countries, and it has one major advantage, which is that it allows a much faster communication with users. Whenever there's an irregularity detected, it's immediately updated in the user's dashboard, so they can correct immediately, like on the same day, and they can immediately see that they corrected it. It's much faster communication between the parties involved, and it's much easier for everybody involved, both applicants and us, to stay within the deadlines that we set out for us. And we're currently studying things internally on how we can migrate to this international system. We're just making sure that all of the requirements that we have for a system are fulfilled by the e-filing system for the MM, and I believe it will be much easier than MM2 once it's on. With that, I'd like to thank you very much for your time. And finally, if you could, please participate in this survey that we're conducting to better understand the needs of our users. You can scan the QR code on the screen. With that said, thank you very much.
Muito obrigada pela sua apresentação sobre o sistema de registro
Thank you very much,
internacional
Felipe, for your
do Brasil.
presentation
E
on
agora
the
passamos
international
novamente
strategy
para o
and
Mariano,
for
como
international protection
moderador, para ver
systems
se
in
há alguma
Brazil.
pergunta.
We now go to Mariano. Mariano, are there any questions?
Felipe, muito obrigado por
Yes. Yes, thank you very much, Felipe, for your presentation. It was great.
Estamos pouquinho retrasados no tempo,
We're a
não
bit
por
behind
culpa
schedule, not because of our
palestrantes, senão por
speakers.
culpa
Let me make that clear.
temos
It's
começado
just because
pouquinho
we
retrasados.
began a
Então,
little
vou
late,
fazer,
so we're a bit behind schedule.
uma proposta.
So I'm going to
tenho
propose
duas
something.
dúvidas,
I have two
mas
doubts I'd like
deixamos
to
para o
clarify,
final,
but let's leave it to the end of the
aquele
session.
painel de,
Let's leave to the roundtable at the end of today's
debate
session.
que temos ao final.
We
Alguma outra
have
pergunta
this round
também
session
sobre
at
o
the end,
sistema
because then we
internacional,
can
mas,
get any
só
other
para
questions
repassar
about the
aqui,
international system and put those
que tipo
together.
de marcas
But I do have
são-
a
pode-
quick question for you.
imaginamos usuário
What types of
brasileiro
mark
que
are we
quer
talking
registrar
about
na União
here?
Europeia. Que tipo
Imagine
de
that a
marca
Brazilian
pode,
user wants to register their mark
pode,
in the EU.
ele,
What
apresentar
types of marks
para
can
no
they
sistema
submit
internacional?
for
Marca
registration
comercial
via the
normal,
international system?
coletiva, etc.
Regular trademarks, collective marks, what marks does it support? The international system accepts all types of mark that its member states can transmit through the system. What varies is that some designated offices may not accept those marks for those types of patents, and then those specific ones may refuse them. Brazilian users specifically have the ability to submit any type of mark they want through the international system. Certain marks, collective marks, position marks, which are not accepted in all countries. So what we do is we send it to our international department, our international secretariat. Our department will submit that mark to those countries that the applicant has chosen, and then those countries are going to get back to us, telling us if they accept those types of marks or not. Of course, applicants can look up in advance what countries accept what types of marks, But
Toda e
we
qualquer marca que ele tenha
ourselves
depositado
don't
no
do this
Brasil
filtering.
pode ser
Whatever
enviada
marks
para o sistema
deposited in
internacional.
Brazil
Aí vai
can be
depender dos
submitted to
países
the
que ele
international
escolher se eles
system.
vão aceitar ou não.
Whatever
É.
the other country is going to do with it is up to each country that
Então,
receives it.
temos aqui uma perguntinha também do público que pergunta, existe uma previsão do acesso ao Madrid e-filing arquivamento eletrônico por parte do INPI? Isso deverá agilizar a dar ainda mais segurança ao processo.
Bom, a
Uma
gente
pergunta é a
está...
opinião, acho.
It's a question and a comment. Yeah.
Bom, então, a gente está
Yeah, okay.
realizando os estudos e a gente
So we
espera
are
terminar
conducting feasibility
até
studies, and we expect those
terminar os
feasibility
estudos,
studies
né?
to
E
be
até
concluded
o
soon.
final do início de dezembro,
Namely,
se eu não me engano, no
I
cronograma.
believe that the
A partir
deadline
daí,
for the
se for
feasibility
aceito,
studies
se a
to
gente
be
achar que
over
tá tudo
by
certinho
early
e
December.
que ele cumpre
And
todos os requisitos que a
if
gente
that
precisa,
feasibility study concludes
a
that
gente
the
vai
system
começar
does
a
work and it
implementação. Aí
fulfills
isso vai
all our
depender um pouco do
requirements, we
cronograma
could
da
go on
ONG
to
e da nossa
implementation.
TI aqui, pra
But
conseguir
that
fazer
schedule will
todo
depend both
o
on WIPO's
procedimento
schedule
certinho.
and how our
Mas eu
IT
acredito
department
que,
schedule is
sendo
looking,
aprovado e
so
estando
that
tudo
both
certo,
can make
eles
things work on
devem
both
pra,
ends.
assim,
However,
assim, fazer
all
uma
things
estimativa, né?
working well and
Ele
everything
seria
going
projeto
smoothly,
pro
I
primeiro
would
semestre do ano que vem.
estimate that this is
Mas,
something
mas não temos,
probably
assim,
that's
não
going
tem
to
como te
arrive
dizer uma
by
data
the first
precisa.
half of next year, if everything
Esperamos
goes
que
well.
dê tudo certo e
Again,
esperamos
I
que no
can't give an
início do ano que
exact
vem
day because it
ele
depends
já
on all
esteja
these things
disponível para
working,
os
but we
usuários.
hope and
Mas
expect that
a gente não
having
tem,
all
eu
of
não
those
tenho como
things in
te dar
place
uma
and
previsão,
working,
infelizmente.
we should have this by
Mas sim,
the
a
first half
nossa,
of next year.
a gente espera que
I'm
ele
sorry I
seja
can't give you a
mais
specific
ágil
date,
e dê um pouco mais de
but we do
segurança
agree.
ao
We do
processo,
expect the
sim.
system to be
É,
much
a
quicker
segurança não é
and to
problema,
afford
mas a
more
agilidade,
safety and
sim,
security
no
to the
nosso sistema
process.
atual, né?
The latter is not really a problem, but the
Então,
agility issue,
finalmente,
indeed, for sure, that's something we want to make
Felipe,
quicker.
você mencionou que o mercado,
Finally, Felipe,
as
one more
solicitudes para o
question.
mercado europeu são
You
importantes, não?
mentioned that the
Relativamente
EU is an
às
important
outras,
recipient of applications
segundo
from
mercado, acho
Brazilian
que
holders of marks.
em
I
termos
think it's
da-
the second
da-
largest market in
aplicações,
terms
não,
of number of
do
applications
registro.
submitted.
Como fazer, como deve fazer
question, therefore, is this.
solicitante brasileiro que quer
How do we get
solicitar
Brazilian
uma
applicants
marca
who are
da União
looking to
Europeia se
get
utiliza o
their
sistema
mark
internacional?
registered in the EU to
Você
use
seguramente
more
mencionou, mas
of the
provavelmente tem
international system?
momento onde ele tem que marcar, não é?
Because I believe there's a
Eu
moment where the applicant
uma
needs to
estra-
check a box,
No
don't
nosso
they?
formulário atual,
Yes, actually, let me
por
show you
acaso, até o
exactly.
exemplo aqui já
I have an
então,
example right here.
você vai selecionar os
In our
países que você
current
deseja
form,
designar,
you
né?
have a field
Países
where
ou
you designate
organizações.
the
Então, no
countries
caso
or
da
the
União Europeia,
organizations
você
to
pode
which
ir
you're submitting your
através do escritório
application.
regional da EUIPO, ou se você
In the
tiver
case
interesse
of
somente em
the
alguns países
EU
membros da
IPO,
União Europeia,
you
você
can
pode
work
selecionar
through the
os
regional
países,
EU IPO office,
membros que você tem
or if
interesse.
you're only
Então, no
interested in a
momento, o
few
formulário
members of the
você escolhe
EU,
para
you
qual
can
país você
select those
deseja
member
designar
states.
a
So
sua-
in
o
the
seu
form
pedido internacional.
itself, you have
E
the
nesse
choice
momento
of
você
what
pode escolher
countries
a União
you
Europeia,
need to
assim,
select.
como a
And the
Fernanda anteriormente
EU
mencionou,
is a
quando você
choice.
designa a União Europeia,
Like
você
my
tem que
colleague
selecionar uma segunda língua de
showed before
trabalho,
me.
né? Assim,
Once you
e
select the
além
EU,
das línguas
you
oficiais
need
do
to select a
protocolo,
working
são
language.
alemão e
And
italiano.
this language needs to be
Mas
in addition to
tem
the
esses
language of the
pequenos detalhes,
protocol,
mas
which is German and
grosso modo,
Italian.
isso tá no
So there are
formulário
those
também,
tiny
assim, no nosso
details,
formulário, assim
but
que
in general
você
that's all in the
seleciona a
form.
União Europeia,
The
você
moment
é
you
obrigado
select
a selecionar
EU,
essa-
you
essa-
are required to select this
essa
second
segunda língua,
language
então não tem
for your
risco disso
application.
não,
So there's no risk
não
of
ser
that
feito.
becoming an impediment in your
Mas
application.
basicamente assim,
We make sure
e
that those
obviamente cada
fulfillment
país,
requirements are
cada
there.
organização tem o seu valor, né?
And then
Então,
we
após a
try to
seleção,
show
você
that
vai ter
every
lá um
country,
campo onde
every
você pode
organization
calcular
has
os
the value
valores
they
e saber
add
quanto
to the
vai-
process.
você vai
There's
precisar
actually a
pagar à
field
Secretaria
that
Internacional
calculates
por
the
esse
amounts for you that says how much you need to pay
Obrigado.
to the
Então, vou
secretary for the
invitar
registration
você
process.
e também os outros
Okay,
participantes
thank you very
do
much,
INPI
Felipe.
que gostassem
So I
deixar
would like to invite
informações ou
you
links
and
no
whatever
chat
other members
para
of the
os
INPI
usuários que estão
to please
participando
leave in
aqui,
chat any
por
links
exemplo, do
for more
formulário
information.
ou informações
Leave,
do INPI,
paste in chat some
que
links to the
é
form, to
grandíssimo
whatever
escritório.
areas in the INPI website that more has information on
Você
this.
a utilizar
The
esse chat
INPI has a lot of information that
passar,
users can
talvez,
access. So please
ao
make use of the chat
na
room.
próxima palestra eu passo a Martins a palavra.
Okay, now
Mas
giving the
invito
floor
você,
back to
Felipe,
Martins.
agradecendo muito a apresentação, de ficar para o final também.
I would like to invite you also to stay,
Obrigado.
which would be great. So thank you. Oh yeah, of course, I will. Thank you very much. Martins?
Última sessão de hoje, que consiste num painel de especialistas sobre estratégias internacionais para a
Today's
proteção
last session
de
is
ecomarcas.
an expert
A
panel on
sessão
international
abordará a
strategy for the
estrutura
protection
de
of
marcas
eco-brands.
registradas no
The
EUIPO
session
e
will cover the
percepções sobre as
EUIPO
marcas de
trademark framework
certificação
and
verdes,
insights into green
diferenças entre as
certification marks.
regulamentações
It would also
nacionais
talk about the
e o
differences
uso
between national
responsável de
regulations
marcas
involved
verdes no
and the
mercado da
responsible
União
use
Europeia,
of green marks in
além
the
de
EU
métodos
market,
de proteção
as well
existentes
as
no
the
Brasil.
protection methods
A
currently
sessão
available in Brazil.
consiste em 3 apresentações,
The session will feature
seguidas de uma
3
sessão de
presentations,
perguntas e respostas
followed by a
moderado por
Q&A session
Mariano Riquet.
moderated once again by
The
Mr.
panel is
Mariano
made up
Riquet.
of IP experts from Brazil and the European Union. And the first speaker is Hugh O'Neill, Head of the Legal Practice Service of the Legal Affairs Department at the EU IPO, who will present about certification marks and green labeling. Hugh worked as IP specialist in the private sector for over a decade before joining the EU IPO in 2010, where he worked in the Business Operations Department and later also as IP litigator representing the EU IPO before the General Court in Luxembourg. In his current role of Head of Service of the Legal Practice Service, he is responsible, amongst others, for the elaboration of the guidelines on examination that reflect the EU IPO's trademark and design practice. Hugh, the floor is all yours.
Thank you very much, Martins. Thank you as well to Mariano and all of those involved in inviting me to speak today. It's a great pleasure for me, and I appreciate this gesture very much. Okay, without further ado, I will kick off. So, a very basic part of what we're speaking about today and tackling in many ways is revolves around the word mark and marking things. No, I mean, we're talking about, in essence, communication. What's the point in having products that are environmentally friendly or sustainable, etc., if you don't have a way of letting people know this in a clear manner? So, not to overstress the basics, but I'm starting quite basic with that concept that a lot of what we're talking about is essentially communication, communicating a message. And I'll look at how you can protect the way certain messages are communicated in relation to the qualities of goods and services via the various kinds of marks that we have. So I'm not trying to be condescending as such, but I do want to start basic and work into the theme that way. So I can press the next, yeah. Really thinking about the fundamental, let's say, the roles that the office has in the office being where I work in relation to this communication function that I've mentioned, it obviously comes down by and large to trademarks. No? And we have 3 different kinds of trademarks in essence: individual trademarks, collective, and certification. Now, what characterizes these in the different areas that they are is essentially their essential function is what we call. The court in the European Judicature often refers to this essential function of these kinds of marks. But essentially it revolves around what message are the different types of marks giving. If we look at an individual trademark, normally it's commercial origin. Where does this good or service come from? No, who's providing it? We get to the collective trademark area and the message changes. The essential function there is really saying that the goods and services marked with this sign belong to someone that's a member of a certain association. So it's a different message than the individual trademark. And finally, the certification mark is a different message again to that extent. It's that this goods and services comply with a certain certification scheme. It could be quite varied, and it means that the stamp on the goods or services you can rely on that to know that they may meet certain requirements. So that's basically the three core functions of these different type of trademarks. Now, often, of course, they're used together, so you'll frequently and normally indeed see a collective trademark used along with an individual trademark. So you will have the individual business marking its product, but also saying that it belongs to a collective. The same for certification marks. Now, there are other differences, but for the purposes of our talk, which is not so long really, I'm focusing on the key ones here. And as that's basically the framework that we have of those three kinds of marks is the framework we have for marking things, let's say, in certain ways. I'm just giving a quick example here of a collective mark. It's quite a famous one, at least in Europe. And it made it to the very top courts in Europe in a case that actually didn't really resolve around the kind of mark it is, but it was revolved about the way it's used. But that's just an example of a collective mark that we frequently come across here. And as I made the point before, it's used, with individual marks to indicate that the packaging in question conforms to certain, is part of an association that ensure the packaging is treated in a certain way. I'm going to focus more on collective marks today, certification marks today. But collective marks and certification marks, they share a certain amount. They do overlap, it's true, to some extent. I mean, I just told you they had a quite different essential function. On the other hand, the way they operate and are structured is similar to some extent. They both have regulations of use, for example. Okay. Now we're getting to the certification mark, which is the new kid on the block in a way for the European Union's perspective. This type of mark at the European Union level came in with the last legislative reform. There were certification marks at the national level in Europe, but this is the first time they came into being at the European level. So a certification mark, it's set out as to what it does, distinguishes goods and services in respect of a number of kind of things. It can be material, mode of manufacture, could be the performance of services in a certain way, their quality, accuracy, as well as other characteristics. So they can certify, for example, and this is what we're interested in today, perhaps more than others, is the environmental, sustainable, organic aspects of goods and services. And they distinguish them from goods which don't have that characteristic. There's an important thing about the European Union certification mark that mightn't apply to the ones you're used to at a national level, but you cannot certify geographical origin by means of a certification, right? My colleague Pilar is a great expert in geographical indications who will be speaking next. And in Europe, there's a whole framework for protecting geographical indications. So it would have been probably a bit too much overlap to have certification rights as well, protecting geographical indication of goods and services. So that's an important aspect of the European Union certification mark. So how does it work? Well, the key aspects of certification marks and collective marks indeed are these regulations of use. It's a whole chapter, let's say, that normal individual marks don't have. And the regulations governing use contain various things. I won't go through in great detail today, but they must contain things like, well, obviously the representation of the mark, goods and services covered, that must be in the regulations governing use. There's a declaration required of the applicant that it's not carrying out a business involving the supply of goods or services certified. Now, that's another aspect of the European certification mark, that there's a requirement of neutrality, let's call it, so that the operator of the scheme is not also providing goods and services that are certified under the scheme of the same kind. There's a distance required there. Another requirement is the characteristics of the goods and services for which certification is requested. So that's an important one, obviously. So what are you certifying? Safety, sustainability, efficiency of some kind, or whatever. That needs to be in regulations of use and elaborated there. There are other requirements, the conditions governing the use, including sanctions, if there's sanctions for not applying properly, not complying with the regulations of use and using the mark, what are the sanctions? And how to test the characteristics and the supervising use of the mark, how does that all work? So when you set up a scheme, that all needs to be set out in the regulations governing use. So it's probably important to tell you that the office assesses if the regulations of use, when it looks at an application, contain the obligatory information, but it doesn't really evaluate the effectiveness of the measures contained. It's not the office's role to deep dive into, for example, the characteristics that you're saying you're certifying and figure out, well, are you effectively certifying or not? The office doesn't go into that. The office does, however, check obvious contradictions between characteristics and the goods and services. Now, we have an example in our guidelines of if we receive a certification mark, supposedly for jewelry, that's certifying sugar-free. Okay, I mean, there's a complete contradiction there, and the office will intervene and say that doesn't make sense, that needs to be amended. But the office's role there is quite limited, really, overall. So that's how they work in a very short period of time I've taken you through. And then you get the end result, obviously various kinds of marks. I've highlighted some here that make environmental claims of one way or another. Obviously, certification marks kind of tend to have a certain look about them because they have to exist amongst other information, though. Normally, if they're on goods and services, or goods particularly, they appear along with other information like regulatory information on ingredients or things. So they normally give you an idea pretty quickly about what as to what they're about. And you have some examples there. I'm sure you've come across them in your daily lives, if not your professional life. So we've gone through basically the way we arrive at a certification mark scheme, the pillars on which it's based, regulations of use in principally, and what they contain. So I've taken you in essence through registration. What I want to do now, and I think is an important part of my talk really, is to make this contrast between the registration process you've gone through and what you meet in the real marketplace as regards regulations around use, because they're not necessarily the same thing, not at all. Registering a European Union trademark is not a right to use the mark. There's no provision in law that says that. I know some national systems are different. There's, when you register a trademark, it's a right to use as such. But under our system, it's ostensibly not a right to use. It's a right to prevent others using. So registration, then we go to use. I think it's a distinction always good to keep in mind as well, because sometimes we can be fixated with registration, all the requirements of registration, and we still have to keep, okay, that's all very well, but when I get to use it on the market, what other hurdles do I have to overcome? And I want to focus today, maybe just to highlight that point in this area, on a piece of European legislation. It's a directive. So under European legislation, the directive is essentially, it's an instruction to the member states to enact provisions. And it's part of this European Green Deal, which comprises various instruments, and part of which is regulating environmental claims. So it's to facilitate better informed, sustainable decisions by users, by consumers. It's also tackle greenwashing. And I've mentioned once or twice, I think I prefer the Spanish term here. I don't know what the Portuguese term is, but it's ecopostura, which is like in English, eco-posturing or eco-posturing or eco-posing. I think it's more romantic than greenwashing. But you know what I'm getting at, and that's what we're going to talk about next, really. So overall, this kind of approach in Europe is supposed to help consumers play an active role in the transition towards an ecological kind of paradigm. So this directive in particular, what does it do? Well, it changes the Unfair Practices Directive, which is an earlier directive, which regulates misleading practices. And what it introduces that's interesting for us is there's new definitions, which is it introduces the concept of a sustainability label and a certification scheme. So when it comes to a sustainability label, it's a very broad term which covers any label, mark, trust mark, etc., that sets out to set apart or promote your goods by reference to their environmental or social characteristics. So a very broad definition, basically, of a sustainability label. So what does the law do? It says that it's an unfair commercial practice to display a sustainability label that's not based on a certification scheme or not established by public authorities. Okay, so it's unfair, it's wrong, you can't do it, basically, display a sustainability label unless it's a proper certification scheme or unless it's a public label. Then it goes on to certification schemes and sets out some of the requirements they have to have. So one of the requirements is that it has to be developed by the scheme owner in consultation with relevant expert stakeholders. That's one of the requirements of a certification scheme. Another one is that the monitoring of the compliance must be carried out by a third party whose competence is independent from the scheme owner, importantly, and the trader. Now, if you reflect a little bit about what I told you about certification marks, yes. Well, the first requirement there, okay, the European the trademark regulation doesn't require this, but it doesn't have anything against it either. So in other words, you can comply with the first requirement when you're applying for a certification mark. As regards the second requirement, again, the European law does not require that the monitoring be carried out by an independent third party from the scheme owner. It doesn't require that, but you could set up the scheme so that it operates in that way. As I mentioned to you, what the certification scheme in Europe requires is that the scheme is separate from the trader. So the trader who trades in goods and services can't also be running a scheme that's certifying them. But the European legislation here seems to go a step further and requires a little bit more independence, I guess, for reasons of accountability, etc. So to conclude there, really, I took you through the notion of registration versus use. Here we have a situation where the requirements for registration, you could see them as strict or comprehensive, but there are some other requirements on top of that when it comes to applying a sustainability label to goods and services. That'll have to be enacted by the member states, by the way, it's still going. So now, that leaves us with one of the key points I really wanted to make there, that schemes can be run, they can be set up under the regulation, but they still have to meet the requirements of the market. This is in line with, if you are a trademark expert, I'm not sure how many are in the audience, but this is in line with principles established here in Europe that, again, yes, use is distinct from registration. And for us at the office, we have Article 7, which is what we look at when we're looking at the absolute grounds for refusal. There are other absolute grounds for certification marks, but they set out what we look at and what earlier rights we look at. And it doesn't require us to look at all of the labeling rules in the market, for example, and decide that, well, we must stop this mark because it doesn't comply with labeling rules. We have a narrow kind of examination requirement there. So if we were to look at the process for registering certification mark, it's not to say it's completely without, there are some protection against misleading claims. There's a requirement that a certification mark can't be deceptive. It's not a very strict requirement. Our deceptiveness rules are not very strict, I would say. I told you that if we see an obvious contradiction when you're applying for a certification scheme, we'll point it out. There's also an area where if you register a mark and then use it in a misleading way, so let's just say you register the mark for one type of certification and you use it for another, it can be cancelled on that basis. There's a basis of public policy and morality for going against marks, but really rules on greenwashing and wouldn't qualify there. So the rules that are around on greenwashing wouldn't, let's say, add up to an objection under public policy and morality. So to square the circle, I didn't set out to make a huge number of points. I really wanted to take you through briefly the registration process for these kind of marks that are giving these kind of messages, that certification marks principally. I wanted to point out that our system of registration has its requirements, but you may well meet other requirements in the marketplace. The system that we have is not contradictory, I don't think, to the requirements that are in the marketplace. You can set up a scheme that is perfectly congruent with the way the mark should be used in the marketplace, but they're not essentially the same thing. And I think that's really the key point that I wanted to make. Of course, any questions, I'm happy to answer later on. Thank you very much.
Thank you very much, Hugh, for your very interesting presentation. And indeed, at the end of the panel, we will have another Q&A session. We now proceed with the second presentation of this panel, which is given by Pilar Montero. Pilar is Professor of Commercial Law at the University of Alicante, expert in intellectual property, a PhD in Commercial Law from the Complutense University of Madrid. She is the Director of the Magister Lucentinus, the Master in Intellectual Property and Digital Innovation of the University of Alicante, which has been ranked as the first master specialized in IP since 31 years. Pilar, the floor is yours.
Thank you. Thank you so much for your kind presentation. First of all, I would like to thank and congratulate the organizer of this seminar. It's really impressive. Thank you to Mariano, to Mercedes, and all the All-Invest team for this invitation. I will complement Hugh's presentation because we have seen the different requirements we need to fulfill in order to register some kind of trademarks, let's say eco or green trademarks, and we have seen the different perspective and requirements we need to follow at EU IPO. And here I would like to focus on 3 points. First of all, I would like to focus on the use of the eco label, eco trademark on the market, and let's say the problems we can face in principle or in theory. After that, I would like to see the different type of trademark regarding the use only. And finally, I would like to also consider the possibility to register eco trademark or green trademark, including geographical indication. And we will see the new perspective we are facing at the European Union level regarding those IP rights, geographical indication, and the issues we can face if we would like to register a geographical indication as a trademark, considering the green or eco characteristic we can find on those kind of trademarks. So first of all, regarding the genuine use, as I told you, I would like to focus on the use on the market. I suppose you know very well, but I would like to highlight the importance to use the trademark fulfilling the essential function of the trademark. So we have seen with you the different trademarks, the different essential function of each one of those trademarks. So we need to justify the use of the trademark, but always consider the way we use the trademark, fulfilling or respecting the essential function of the trademark. And I think this is really important, and we will see, I will present or give you some examples, sometimes with case law, others without a real case law, but I found on the market the use of those kind of trademark, and I would like to share with you why perhaps those trademarks could be in danger. So first of all, I would like to show you this trademark. It's a registered trademark at EU IPO, registered as an individual trademark for class 29 for olive oil produced using sustainable methods. And you can see there aceite de oliva, producción sostenible, sustainable production in olive oil. The trademark is the sign you can see in the left, I mean, not in the products, but after I look how this owner used the trademark in the market. It's true that, of course, I make this search by in internet, so perhaps we need to go further and to look for more examples. But in any way, I think it's a good way to see how we use this trademark in the market, and if this kind of use could fulfill the essential function of the trademark. So if you see the Carbonell oil, the bottles Hojiblanca and Carbonell, I don't know if you can see very well in the slide, but we find this label, the label of olive oil sustainable production. But this is my opinion only, of course, but in this case, if we register this trademark as an individual trademark, we need to use the trademark in order to inform the consumer regarding the commercial origin of the trademark. And in this case, we have different olive oils from different companies with the same label. So I think it could be at least a risk for the owner of the trademark. Another example I found, I need to confess that it's not very easy to find these kind of examples because, of course, I suppose, or I think the different owners try to register in a very good way the different signs. In this example, we have another individual trademark, European Union, registered at EU-IPO for classes 29, 31, so fruits, frosted fruit, fresh fruits, etc. And you can see there Fresón Sostenible, Sustainable Strawberry, etc. in several languages. And if you see in the examples, we can see Fresón de Palos, one kind of strawberry, and Fresón Sostenible, the sustainable strawberry label, you can see in the package. But again, as it was the case in the previous slide, we are not informing, at least in this example, the consumer regarding the commercial origin, which is the essential function of the trademark. And why this is important? Because in this case, you can see this is a very famous case at the European Union level. We had an individual trademark for pumpkin seed oil, produces fulfilling the PDO product specification, Steriches Kurkis. It's very difficult for me to pronounce that, sorry. So in this case, we have an individual trademark. This trademark was owned, or the owner of this trademark was a public institution whose tasks include ensuring the sustainable management of the agriculture and forestry in Styria. And this public institution licensed the trademark only to the producer fulfilling the product specification of the PDO, the geographical indication, in this case, a PDO. In this case, the Court of Justice and the General Court and the Court of Justice consider that the owner of the trademark is not fulfilling the essential function of the trademark, because the use they are performing in the market is not respecting the essential use of an individual trademark. So it's for that reason that in this case, the Court of Justice considered that any owner, proprietor of an individual trademark who has his good manufactured by other undertakings may lose his rights. And in this particular case, the use of this trademark allows consumers to identify a geographical origin and the qualities associated with this, but fails to indicate that the goods come from a single undertaking responsible of their quality. So they are not fulfilling the function of an individual trademark, and for that reason, this can be dangerous for the individual owners. After we have seen the problems we can face if we register, let's say, an eco label as an individual trademark, but we have seen with Hughes the possibility to register other kind of trademarks, particularly collective trademark or warranty or certification trademark. In the directive, we have the two possibilities regarding the name, warranty or certification. At the European Union level, we have certification trademark. For instance, in Spain, we have warranty trademark. In Portugal, they allow both names, collective warranty or certification, but it's the same. We have seen the essential function, and here I would like to focus on the use in the market, because we have seen the requirements we need to fulfill to register those signs. But after the registration, we need to respect the essential function in order to maintain, in order to keep the trademark. In this case, I found this is, again, not very easy because, for instance, regarding collective trademark, it could be a little bit easier, but regarding certification trademark at the EU level is not so easy because we have less cases nowadays, of course, because of the timing. But regarding the first type of trademark, regarding collective trademark, we can see this sustainable wine growing registered at the EU IPO in class 33 for alcoholic beverage, wines, protected appellation of origin, etc. And looking for the function or perhaps the goal of this trademark, we can see in the web page that this trademark has been created by Vigneron and Développement Durable, French one, association bringing together different wine growers committed to a sustainable and corporate social responsibility. In this case, they state that sustainable wine growing approval is the first sustainability certification dedicated to the world of wine in France. So in this case, we have a collective trademark owned by a collectivity, as Hugh said, so it's respecting the requirements of a collective trademark, but we need to see if in the market they are fulfilling the essential function. I mean, if they are using this sign, this label, as a collective trademark in order to inform the consumer about the commercial origin. And the commercial origin will be collective because we have an association. It's true that, as Hugh mentioned, we can also have some kind of overlappings because we have a regulation of use and we fulfill some specification in order to have the collective trademark, but the essential function is somehow closer to the individual trademark because we need to inform the consumer about the commercial origin. And after, of course, we can, on top of that, inform about other characteristics. In this case, it's not so easy to find examples. For that reason, I took the same as Hugh mentioned at the beginning, in order to show the possibility to consider the fact that a collective trademark, for instance, the previous one, the winery, regarding the winery, sustainable winery, could prove a genuine use if they can prove the same we found in this case. Why? Because in this case, even if sometimes it's not very well known, at least for the public, in this case, the green dot informed the consumer about the possibility, or is a label in which we can find the packaging whose companies belong to a different collective system known, for instance, in Spain as Ecoembes, Ecovidrio. And in this case, we inform the consumer with this logo that the company has paid an amount for placing its container on the market. And in this case, we can consider that this particular logo can inform the consumer not only about the possibility to have this kind of sustainability requirement, but also to the fact that the different producers using this label are part of an association. And it's for that reason that this trademark could be considered, used in the market, fulfilling the essential function, which is not always the case, but it's true that it's not so easy to find in the market the examples regarding collective trademark with sustainability requirements. So in this case, I would like to highlight the problems or the issues we can face regarding the third kind of trademark, certification trademark. We have seen the information provided by certification trademark. In this case, we have a very different essential function if we compare with collective and individual trademark. In the previous one, we are informing about the commercial origin, but here we are not informing about the commercial origin, but about the characteristic. So we have seen also the specificities regarding the geographical origin at the European Union level. I would like to show you these examples. We have this certification trademark registered at the EU IPO for classes 18, food and products made for food. And in this case, we can see the use of this trademark in the market. So I think in this case, it's clear that this kind of trademark is respecting the essential function because they are not informing about the commercial origin, they are not informing about the companies, they inform only about the characteristic of this particular of the different goods made by Ford. I would like to highlight perhaps something relevant. As Hughes mentioned, certification trademark cannot be used at the European Union level in order to inform about the geographical origin of the products and the characteristics links to this geographical origin. This is something very specific for the European Union certification trademark. Why I said that? Because it's not the case in all the different countries. Depending on the countries, we can perhaps have a certification trademark in order to inform the consumer about the geographical origin. This is the case, for instance, in Spain. In Spain, we have warranty trademark, marca de garantía, and in this case, we can inform about geographical origin of the products, and it's possible in Spain to have this kind of trademark. In Brazil, if I am not mistaken, is the same thing, but for instance, in Portugal, it's not the same thing. So we need to see this kind of trademark, the certification trademark, it's less harmonized in Europe, but also in other countries. So for that reason, I think is really interesting. And here we have, this is another example of a certification trademark used as a certification trademark. So I think there is no problem here. So we have Revolución Moda Sostenible, sustainable fashion. In this case, it's the search I made in internet, it was really successful, but in order to inform the consumer about the characteristic of this trademark. So it's from a point of view, it's a good or a right use of the trademark fulfilling the essential function. And here, even if it's not, of course, perhaps eco or green label, or perhaps yes, I don't know, this is another case, I think, very important regarding the use of a trademark in other ways or fulfilling or not the essential function. And I think it's interesting to highlight the position of the European Court of Justice, because the court considered that the affixing of an individual EU trademark on goods as a label of quality is not an use as a trademark that falls under the concept of genuine use. So if we have a label and we use the label as a certification trademark and it's registered as an individual trademark, we are not using the trademark and we cannot prove a genuine use, and it's a risk for the owner of the trademark. And of course, I will not have time for everything I would like to show you, but in any case, perhaps I would like to highlight the possibility we have at the EU level to register geographical indication as a trademark. First of all, I would like to perhaps share with you the importance of geographical indication regarding the Sustainable Development Goals. Why? Because geographical indication are ways to promote some of the Sustainable Development Goals. And I think it's really interesting to see the possibility to fulfill those requirements, I mean, to really help different Sustainable Development Goals by the way of geographical indication. Of course, geographical indication we are facing a different intellectual property right, but we can have the possibility, or we can think about the possibility to register a geographical indication as a trademark. In this case, I showed two examples regarding geographical indication helping the different communities, one in Colombia, another in Chile, in order to help the communities and to respond or fulfill those Sustainable Development Goals. And in this regard, I would like perhaps to share with you the importance of the new regulation at the European Union level regarding the sustainability goals of geographical indication. As you may know, at the EU level, we have now two new regulations, one for craft GIs and another for agricultural GIs. And particularly in the second one, the agricultural regulation, we can see lots of references to sustainability in this regulation. And I think it's important to take into consideration this fact. Why? Because we have seen lots of geographical indication in the market fulfilling this essential function and naturally driven or naturally guided by oriented on sustainability. So if we register a geographical indication as a trademark, we can have sort of green trademark, but we can also face other kind of problems with different solutions in the different countries. And this was my last slide. In this slide, I would like to show you the difference we can find at the EU level and also in different European Union countries, national member states. Why? Because here we have the problems against the geographical indication Méditerranée, French one registered for wines at the EU level, and we have the trademark here, Barcelona Mediterranean wine. I like this case because at the EU IPO, they consider that this trademark could be registered, even if it includes Mediterranean in the trademark, because the fact that we have Mediterranean will not make this connection in the mind of the consumer regarding Mediterranean as geographical indication. And for the moment, we will see, but for the moment, it has been registered at the European Union level at EU IPO. But at the national level in Spain, we have several court decisions in which the judges consider that this kind of trademark could not be registered because they can make the consumer think or have this link in their mind regarding the Mediterranean geographial indication. I would like to point it out this because I think it's interesting to see the differences, the different case law in member state and at the European Union level, in order to fulfill the different essential function of the trademark. And in this regard, I suppose we will have more practical cases in the future regarding not only certification trademark, but also geographical indication included in trademark. And with this, I leave it here, and I am, of course, available for any questions or comments. Thank you so much.
Thank you very much, Pilar. I'm sure that at the end of the panel, we will have some questions. For the last part, I switched to Portuguese again. Agora prosseguiremos com a terceira apresentação deste painel sobre estratégias
with the third presentation of this panel, International Strategy for the Protection of Eco-Brands. The presentation will be by Patricia Barbosa, examiner of geographical indications and marks, including collective and certification marks, and the INPI in Brazil. Patricia has a postdoctorate degree in intellectual property Innovation and Development from the INPI Academy of Intellectual Property Innovation and Development, where she works as a collaborating professor and teaches the subject, geographical indications and other signs of collective use. Patricia, you have the floor. Thank you very much, Martins, and a good morning from Brazil and a good afternoon to those of you in Europe. It is a pleasure and an honor to have this opportunity to talk to you a little bit about a topic that I like so much. I hope that you can see my presentation. I believe so. So let's proceed. I will touch very quickly about these international strategies for the protection of eco-brands. And I will very quickly bring your attention here to one thing. This is just a quick highlight on how brands are present in our everyday life. In this one picture, we have 4 types of protected marks in Brazil. Actually, I will start with 3 and then go into the 4th one, which connects with what was being said here before about certification marks. We have one service mark here, which is a coffee shop. A coffee shop can have a service mark, or even the producers of those services can have a mark for that service. And I'm sure those of us getting close to lunchtime are looking at this already and thinking of their own lunch. But there are also product marks here that can be granted to any of the products in this table. The paper, the napkin, the cup, the bowl. And there's also a collective mark possible here. Maybe the coffee here belongs to a collective mark. Maybe there's a product mark for the individual coffee, but also it could be labeled with a collective mark indicating that the producer of that coffee is a member of an association or a cooperative or a collective organization that works together and whose products are identified by a unifying mark. But we could also have a collective mark. Maybe all of the fruits and jams in this banquet here could be identified as the product of a collective origin. So going back into collective mark, Brazil has a few of them. You're seeing some of them on the screen now. Maybe that strawberry in the picture was produced by a family farming cooperative. or it was produced by an association of black women planting in the Cerrado, which is a very specific Brazilian biome, or it was produced by somebody with a specific type of disability. That's what the collective mark exists for, to indicate how a product is used by the members of a community.
Nós poderíamos destacar a marca
About
de
the coffee,
produto ou ainda
about this
uma
coffee here,
indicação
you could have a
geográfica.
product
Que,
mark
no
identifying the
caso,
product,
seria a
or
mantilha
a
de
GI
milho.
mark,
E qual a
which
diferença
in
da
this
marca
case
para
is
uma
a
indicação
tag
geográfica? No
marking it as a
Brasil,
product from
nós
Minas
temos o caso de
Gerais.
Mantiqueira de Minas, que eu trouxe para destacar para
So,
vocês,
what is the difference
porque
between
foi
a
a
GI
primeira
mark and
indicação
a collective
geográfica
mark?
que foi
In
alterada.
Brazil, they sometimes
Até 2018,
overlap.
quando uma indicação
There's this one
geográfica
place
era
in Brazil
registrada
called
no Brasil,
Mantiqueira
não
de
existia essa
Minas.
possibilidade de
And up until
alteração.
2018,
Mas a partir de
whenever a brand
2018, nós
was
passamos a
registered in
proteger uma
Brazil,
indicação
we
geográfica,
couldn't
nome
change the
geográfico
brand.
específico ou ainda gentile.
But
No meu
after
caso, né, o gentile, como eu sou do
2018,
Rio de
we
Janeiro,
started being able
seria
to
carioca.
protect a
No
GI
caso de
or a
Mantiqueira
specific
de Minas,
GI and a
antes ela
Gentile
era
or
registrada
a,
como uma indicação de
a
procedência.
demonym.
E
Basically,
atualmente, após a alteração, ela
the
passou a
name of a
registrada como uma
region
denominação de
can
origem.
be
E qual a
identified
diferença
in a
em cada
mark
desses
as a
registros?
protected mark.
Na indicação de
And what is the
procedência no
difference for
Brasil,
each of these
e isso é uma diferença
registrations?
muito grande da União
In
Europeia,
Brazil,
já que
when
na
you
União
indicate the
Europeia
provenance of
existe
your
o
product,
nome,
we have a major
indicação
difference with the way the
geográfica
EU
e
does it.
denominação de origem. E no Brasil
In the
existe
EU, you
indicação
have
geográfica, que se
GI
divide em
and
duas,
OD,
sendo uma
while
indicação
in
de
Brazil we have
procedência
two
e a
types of
outra
GI.
denominação de origem.
We
A
have a
diferença
GI
principal
for
entre
indication
essa
of
primeira
origin
imagem
and a
aqui da
GI for
indicação de
denomination
procedência,
of
que
origin.
era a região da
So,
Serra da Mantiqueira de Minas
the
Gerais,
indication
é
of
que para
provenance or the
receber esse
indication of
registro
origin
de
of this
indicação de
is the
procedência,
Serra da
a região
Mantiqueira
teve que
region.
comprovar que ela tinha uma
Basically,
reputação.
this
Ela
region
já era
had to
conhecida
prove to
pela
us that
produção
it
de
had a
determinado
certain
produto, nesse
reputation,
caso o
that
café.
it was known
Para
for
conseguir
producing a
esse
certain
registro
type
de
of product,
denominação de origem,
namely coffee.
Mantiqueira de Minas não teve
But
que
in order
comprovar
to
essa reputação,
obtain a
porque na
denomination of
nossa
origin
legislação
certification,
não é
it didn't
obrigatório
have to
que haja
prove
essa
that,
comprovação.
because
É
for DOs
necessário que a
specifically,
região
that's not
comprove
needed.
que ela tem
What's necessary
características
is
específicas
just for the
que
region
são
to prove that it has
decorrentes do ambiente
specific
local. E
characteristics
nesse
that are
ambiente,
due to
eu
its
chamo a
natural
atenção que seria o
environment.
ambiente por inteiro, incluindo a nós humanos.
And
Ou
this is the
seja,
full
as
environment,
características
including
daquele
people.
produto são
Basically,
decorrentes
the
daquele
characteristics
ambiente,
of that
daquele
product
local, e
arise
nós,
from that
humanos, que estamos
place
naquele
and
local,
from the people in
descobrimos
that
como
place as
fazer
well.
para que o produto tenha
Basically, it
características
indicates that the
específicas
people who
que
live
você
in
não
that
vai
place
encontrar
have found
se
a way to
aquele,
make
por
that
exemplo, aquela
product that
mesma
gives it
muda de
unique
café tivesse
characteristics.
sido produzida em
A
outro
denomination
local.
of origin
Então, a
basically
principal
indicates
diferença
that
entre
whatever
indicação de
other coffee
procedência e
produced
denominação de
everywhere
origem,
else
nesse
is
caso,
not
que
going to
nós
taste the
para
same.
vocês, e na
This
legislação
is what we
brasileira,
call
é a
an
questão
indication
da
of
fama,
origin.
da reputação.
It is
Aonde só a
basically about
indicação de
reputation.
procedência
It's
tem
about
essa
fame.
exigência para ser
And in
registrada no
Brazil,
Brasil.
only the
E como eu
indication
falei
of
com
provenance,
vocês
as we
agora,
call it,
muito
indicação de
brevemente, sobre marca
procedência, has
coletiva
that
e
demand.
indicação
Denomination
geográfica,
of origin
eu queria
don't.
destacar que ambas
Now
podem
that I
ser
talked about
responsáveis por
denomination of
identificar
origin
uma
and
origem,
indication
e
of
até foi
source,
falado pelos palestrantes
I want to
anteriores muito
highlight the
bem,
fact that they can
aonde
be
numa
both
marca
used to
coletiva,
indicate
a origem
origin.
empresarial
The
é a
difference is that
coletividade. Ou
for
seja,
a
numa
collective
marca
mark,
coletiva,
the
o
business
foco
origin
está
of a
nas
product is
pessoas,
focused on
daqueles que
collectivity.
produzem
It is
determinado
basically
produto
focused on
ou prestam
people,
determinado
making sure that there are
serviço.
multiple
Já no
people
caso
providing
de
a
uma
certain
origem
product or service.
geográfica, é
When
claro
we
que as
talk about
pessoas
GI,
estão
though,
presentes, como eu
we
mencionei,
still
mas
have
o
the people
principal
present, of
enfoque
course,
é a
but the
região em
focus is
si.
not on the
É
people,
aquela
it's on
área
the
que tem
place
que
itself.
obrigatoriamente
It's
ser
in that area
delimitada
that has
oficialmente
necessarily
para a
to
produção de
be
determinado
officially
produto ou
delimited
serviço.
as the
Então,
area
essa é uma
wherein a
diferença
certain good
crucial
or
na nossa
service is
legislação
produced.
com
That's a
relação
crucial
às
difference in
marcas
our
coletivas, em
legislation when
especial,
compared
e
with
a
collective
indicação
marks,
geográfica.
and particularly
Eu
with
gostaria de chamar a
geographical
atenção de outra
indication.
particularidade no Brasil.
And
As
another
IGs não
particularity
podem
in
ser
Brazil,
comercializadas na maioria dos
GIs
países. No
cannot be
entanto, no
commercialized in
Brasil,
most
as marcas
countries and
coletivas
cannot
também
be
seguem
and have
essas regras.
specific
Na maioria
rules
dos
for
países, as
registration.
marcas
The
coletivas
same
podem
goes for
sim ser
collective marks in
comercializadas.
Brazil.
Podem ser
In other
vendidas,
countries, collective marks marks can be commercialized, can be sold, can be transferred. But in Brazil, as a means to try to preserve this collective origin, collective marks cannot be traded. And both collective marks and GIs have very specific rules for registrations that differentiate them from position marks, product marks, and collective marks as well.
Com esse trabalho publicado já lá em 2013, aonde essa questão de uma marca poder
the fact that sometimes one mark, one brand is referring to an environmental issue behind the name. So there is an old work that was carried, an old paper that was defining the X and Y, so certificate and CO, they would be able to ease people's conscience, for instance. And why is that? Because people with correctly aimed objectives about the product that they are about to consume, so they believe in the information that the brand communicates to them, and that might be through a collective mark or certification mark or an individual one. So and when it comes to the example of coffee, I like to draw your attention to the fact that coffee is one of the products that has the highest number of certifications. And we know that this sector, there are different certifications that apply to different niches. In Brazil, that's one of the main segments for geographical indications. And by the way, there is a platform that's being developed to contemplate geographical indications that are environmental friendly. But then when we go to the fourth type of mark that's protected in Brazil, which is the certification mark, and that's why I'd like to tell you about this recently published paper. It's a doctorship thesis, and our student, it's a student from the NPI, and he was working on that, on the marks that were patented, and they were certification marks that have been filed for its patent. And his research identified that amongst 67 registered marks, certified marks that were registered, 55% of them mentioned sustainable development, and amongst those, 54% belonged to foreign holders. So another interesting point I'd like to draw your attention to. So he studied the register during 5 years, and so only 67 of them were certified marks, and Brazil usually has around 1,000 applications. So if you consider the number of certification marks that were accepted, you can think about the high specificities that are behind the criteria to accept such registration, such certification marks. Our geographical origin, according to Brazil legislation, it's only protected following certain rules. And also, I think it's wrongly written. It's written that's from 2014, but it's not. It's the current year. They have identified this. Scholar identified that 60% mentioned social environmental criteria, while 22% mentioned only environmental criteria, and 80% refer to social criteria. So it's important to highlight that, because when we are discussing ecological marks on eco brands, sometimes the social aspects are not taken into account, and usually they are the ones that provide the respect of the environmental criteria, the fact that it's a social environment. So in these technical documents, there is some degree of adherence to one of the 17 Sustainable Development Goals of the United Nations. But those goals they had different degrees of adherence. They were considered, they were divided between low level, medium level, and very low level. So he was able to develop a specific strategy to be able to quantify the level or the degree of adherence specific to that documentation. And he found out that even though they were mentioned, they were indirectly mentioned. That means that the studied certification marks, they were not contributing to achieve the SDGs, any of the SDGs, and the goals that were contemplated the most. He was able to identify that the main factor on the certification marks were about fresh water and sanitation. So that has a direct relationship to the process we are undergoing currently. And also he found that the goal that was least mentioned was to eradicate poverty, which was the first one. So he made a comment, and the reading of that, the interpretation of that certification marks are still to this day not very well known, and they could be strategic, even though they could be strategic tools for the promotion of the GDS of the 2030 Agenda of the United Nations, as we mentioned at the beginning of the seminar today, but they have not been used as much as they could. And it's interesting because certification marks, they exist to prove that some specific technical criteria are being fulfilled. So the certifying issuer, the one that certifies the trademark, they verify if the service provider or the producers of some goods, they are in accordance with technical rules. That's a way of communicating to the consumer that pays attention to that kind of criteria, that there is a certain control about the content inside the package, even though certification systems may represent elevated costs, and sometimes they are even considered a hurdle for a higher or a bigger group of producers and or service providers. Actually, I bring a different perspective. There are some programs presented by Brazilian government, the national Brazilian government, that they focus on such criteria, the environmental ones. And you can see family agriculture, for instance, or the quilombos, which are ancient former slaves groups, products that are focusing on that, and therefore they are looking for the green seal, or and also the art products, which are focused on crafted products. So, and we discussed it for the concern about carbon. That would be another program that could be included. And precisely when we consider and reflect upon energy consumption, we could identify better ways of using energy. And that's what applies to this brand here. For instance, when you buy a refrigerator or an air conditioning, you focus on that seal that tells us that it consumes less energy. So how could we use everything in one only in one picture? We have the CO, the certification issuer mark, and there are different marks that could be different ones because the certification company might have different certification marks. So technical features, that distinctive technical features. So that, in a brief manner, is what I'd like to share with you today. So I highly recommend you to go to our portal, to our webpage, and check geographical indications, certification marks, and there is a detailed step-by-step way of filing for brands for certified marks.
Obrigada e espero ter novas
Thank you very much, and I
oportunidades de conversar com
hope that
vocês, além de
soon we'll
agora
get
com
together for new discussions. And now we are going to the question and answer section. Thank you very much, Patricia, for your presentation. We open the floor for questions, and I will pass the floor to Mariano. He's going to be the panel moderator, and he will bring us the questions. Thank you very much, Matiz.
Brilhantes apresentações.
Brilliant presentations here. We are getting to the key topic of the seminar. Thank you very much, Pilar, Patricia, for such a rich panel.
Ao final, tínhamos previsto também
We had defined that we could have a concluding roundtable, but due to time constraints, I think we are going to do everything together, question and answer and concluding roundtable. Because I do have lots of questions to ask you. There are some of them being sent by our chat. So there is a question, a very straightforward.
My phone now. Somebody's phone is on there. Hugh, we were talking about certification marks and the requisites to register today in EU IPO. Nevertheless, there is a legislation, a directive, which is, let's say, in the course of evolution. But today, what would be the requisites for a Brazilian, let's imagine a coffee producer that would want to certify, the owner of the mark that certifies, let's say, certain environmental qualities, okay, let's say good use of water resources or something like that wants to certify that or make use of that certification in Europe. Okay, so he comes to UIPO, and what happens next?
Well, it depends on who's coming. I mean, we have the person who wants to set up the scheme, let's say a certification scheme, as I said, can't be a trader in coffee. So it's not going to be somebody who's trading in coffee that set up the scheme. So we need to get that out of the way, that we have this distance between them. After that, the process is the application process just has the normal requirements of the sign, goods and services to be covered. And really the certification aspect of it, I think, comes into play with the regulations of use. So those regulations of use that must accompany the application, which contain required information. Some of it is quite formal, names, declarations, etc. But others is really where you set out your scheme. So you say something like the coffee, this mark will certify that the coffee in question is grown in a certain way, using a certain fertilizer only, etc., etc. You will set out, so they would be the characteristics for which you're certifying. And then you'd set out the conditions governing the use of the EU certification mark. So sanctions that you apply, you have scheme for monitoring the people that are applying their mark to the products. That needs to be in regulations of use as well as a testing system. How does something meet or not meet those characteristics? So the regulations of use really give you this framework to set up your certification scheme. And what the office has are kind of templates for filling out regulations of use. Now, they don't go in, they're not templates as to, for coffee or for different products, but they're templates on what you need to include, and it kind of gives a certain order. That's worked very well, actually, because at the beginning, when we opened the process of certification marks, people weren't sure how to structure regulations of use, etc. So I guess the system here is based on this notion of transparency, I suppose. All of the details of your scheme are set out. People can see what it is. They can see how you police it. They can see what you require. and then they can determine if that's a, you know, if that's a useful way, if that's a valid way of making, you know, making that claim that you're making. So that's the way it works. As I said, there's no geographical indication kind of aspect to it. There's no geographic certification aspect to it. But other than that, it's quite a broad scheme.
Okay, thank you very much. Yes, very, very clear. For Pilar and maybe for Patricia too, at the national level, sometimes there is, for certification marks and schemes, there is, if I recall, maybe in Spain or maybe in France, the intervention of a competent ministry which might be involved. Is this correct? And I just wanted for you to give us some insight, and maybe for Brazil as well, if this is for the Selo Verdes, if there is some kind of previous I don't know, certification or validation by ministries which is required of a
May I?
competent. Yeah, you can lead the way.
Sim, no caso dos programas de governo que eu mostrei,
In these government programs that I shared with you on that previous slide, yes, they are specific government projects connected to the respective ministries. One of them, which is the brand, the seal, that's Procel, that's used for energy consumption processes, that is filed as a certification mark in the INPE. But there is no other certification regarding government programs. We have different seals of that act as validation. They are on different level, national, regional. So the entities, the governmental bodies, are responsible for those seals. So there are some specific laws that create seals that will be identifying specific products that follow the criteria that were predefined. So there's the organic program that's highly acknowledged in Brazil and has been in use for years, and it has 3 different ways. The first is the more traditional one. It's the third-party audit, and then the producer itself can define if they are following the requirements, and then there are another possibility to verify if the rules are being followed. But when we carry out the filing of a certification mark that has no relationship whatsoever with the government, no, it doesn't. The ministries have nothing to do with that. That's the office competence only. So we decided. So in the last case, it would be similar to the European process, right? When there is no government program involved, that's the process, the filing process is made at the intellectual property office, and that's the way to go, right? Did I understand correctly?
Precisely. And Brazil also has an interesting idiosyncrasy. We only protect certification for goods and services. We don't protect certification mark for green processes. Processes cannot be protected by a mark. You need to identify exactly what services provided, which service is actually being controlled by that mark. We don't certify people. We certify services provided by people.
Pilar.
Okay, thank you.
Pilar, do you want to address the part of the question that was for you?
Yes, thank you so much, Mariano. Indeed, in Spain, we do have this exigent requirement regarding certification trademark, and in Spain, as I told you, it's called warranty trademark, but it's the same essential function. And we need, as a requirement, the authorization of the legal authority, the authority competent regarding the kind of product. So usually it's the Minister of Agriculture, the Minister of Industry, depending on the product. We need this certification. Otherwise, the application will be refused. And we have cases, I mean, if we don't have this certification, the trademark will not be registered. So it's important to tackle and to know. Sometimes it's not very easy in Spain to know the minister competent for those kind of certification. So it's something that in some cases is really an issue for the owners. But it's important to take into consideration. Of course, we can also we can approach the OEPM, the Spanish office, and they can tell us if we have doubts. But it's really important because otherwise our application will be refused. And regarding the Brazilian system, it's in Spain. We do have also sometimes governmental trademarks. I mean, a public system regarding different processes. In those cases, usually the government, regional government or the national government will register also a certification trademark, I mean a warranty trademark. We will have the public process in order to warranty some kind of requirements of the products or services, but usually the government, and as a warranty trademark can be owned by a public institution, will register the warranty trademark at the OEPM, at the Spanish Patent and Trademark Office.
Thanks very much, Pilar. Concerning the matter of this coexistence between our system in the European Union, which works with the EU unitary system and national systems as well, there is a question by Carlos Mauricio Ardizone referring to the Barcelona Mediterranean wine case that you brought up, Pilar. But I think that it's a more it can be amplified. It's a more general question on trademark law and on our system. It's considering the differences in the decisions in the national at the national phase in Spain and the European institution. Does this mean that the trademark would not be able to be used in Spain, but yes, in the rest of the continent?
Thank you so much. Of course, if that's not the case, because if, as we are in Spain at the European Union, if we have an European Union trademark, we can use the trademark in the whole country, I mean the whole territory. So, but we need to consider, or we need to fulfill the requirements regarding the European Union trademark. We need to see, I mean, this has been a first decision, so we need to see if this is confirmed, at the end. But in this case, it was a little bit more complicated, because at the national level, the fact or the problem was that the judge considered the trademark could be misleading for the consumers, because those owners, according to the judge, needs to have the authorization of the Consejo, of the producer associations. This is something which were not in the regulations, in the agri-food wine regulation. So this is my opinion, but in this case, I think it was a little bit not very correct, if I can say that, because we cannot consider the trademark is misleading because we don't have the authorization of the producer association, the Consejo Regulador, because we don't need this. We didn't need this. We didn't need this authorization. It's true that now we will see, because we have new regulations with differences if we compare craft and agricultural products. So now perhaps the decision could be different, but at this moment, these were different cases, 3 cases at the national level several years ago. We didn't have this requirement. So if we don't need the authorization of the producer association, we cannot consider the trademark is misleading because we don't have this authorization, because we don't need it. So it was a little bit, from my point of view, a little bit confused. And in this regard, I understand better the EUIPO decision, because I think it was in this particular case more coherent. We will see. I mean, we will see in the future. We will see if this decision is appealed or not. But it's true that nevertheless, we have still sometimes differences between national and EU cases, and we can have this kind of solution. In any case, if we succeed to have a trademark register at the EU level, we can use the trademark at the EU level. It was the same case, even if it wasn't eco label, with the La Mafia se sienta a la mesa, you know, this trademark regarding a restaurant very well known in Spain, I think, at least in Alicante. And the trademark is registered at the national level only, but not at the European Union level, because it has been considered contrary to the public consideration. I mean, the public policy. Thank you, Mariano. And I mean, we have only a national trademark for this restaurant, so they are using the trademark, but they don't have an European Union trademark in the whole territory of the Union. This is the beauty to have both systems, and we need to deal with both at the same time. Thank you.
Okay, thank you very much. I've been kicked out of the meeting slightly, so I missed a little bit of your presentation right now, what you answered, Pilar. But we are at the end of our time. We are right on the end of our time, so spot on. There are many more topics and issues that we could take on from here on this. I just wanted to also point out that I appreciated very much, also from the point of view of Pilar and Patricia, the introduction to, and the relation, creating a relationship in your presentation, a relation with GIs, because this is a very important topic for Alinvest Verde, and we are sponsoring right now mentorships in Brazil and Argentina and in Paraguay concerning the use of GIs to provide add value to sustainable productions. What you all presenters today mentioned is very compatible with this, the relationship between other marks, you know, like collective marks or certification marks and GIs. Certainly, GIs are not made to promote sustainability, but there is, as for the rest of society and instruments we use, there is a need perhaps to establish these relationships, and other trademarks can help in this sense too. I just want to thank all presenters today. This has been a very, very successful seminar on behalf of our project, Alinvest Verde IPR. Thank you very much for being there at EUIPO and in Brazil, in INPE, and for helping us establish this bridge and this, let's say, green gateway that we are working through with IP in the middle. And I give the floor back to Martís for the last words of the webinar. Thank you.
Thank you very much, Mariano. Can you see us? I just wanted to double check, since we also have Monica here with us, who returned for the round table.
I see you are all there. Yes, looking very good, everybody.
Okay, good. So I will switch to Portuguese again then. Muito obrigado, Mariano, por encerrar o evento de hoje.
Thank you very much,
E com
Mariano,
isso
for
chegamos ao
closing
fim do
today's
primeiro
session.
dia das
And
jornadas
we
virtuais de
now
2
are
dias
at the
sobre
end
o
of
uso
day
de
one
direitos de
of our
propriedade
two-day
intelectual,
journey of seminars
hoje
on the
especificamente
use of
sobre
intellectual
marcas
property
registradas,
rights
para
Today,
promover o
specifically,
comércio
the use of
sustentável entre o
trademark
Brasil
to
e a
promote
União
sustainable
Europeia.
trade between Brazil
Esperamos
and the
recebê-lo
EU.
amanhã para o segundo
We hope
dia
to see
dessas
you back here
jornadas
tomorrow
virtuais.
for the second day
Amanhã o
of our
foco será no
virtual
papel que
journey.
desempenham os desenhos
Tomorrow, the
sustentáveis
focus will
na
be
inovação
on
e
the role of
criatividade
sustainable
na União
designs
Europeia.
in innovation and
Antes de
creativity
encerrar
in
o
the
evento,
EU.
gostaríamos de tirar uma
Before
foto
adjourning
de
for today,
família.
we would like to have a quick
Portanto,
family
aqueles que
photo.
quiserem
So
aparecer na
please,
foto,
those of you who
agora
want
é a
to
hora
appear
de
in the family
ligar a
photo,
câmera.
this is the
We
moment
will
to
now
turn your
take a
cameras
family
on.
picture.
We
So
will take a
please
quick
turn on your
family
camera
picture.
if you would like to appear in the picture. And we'd like to ask the conference technicians to be so nice to take a picture of us. Vamos aguardar alguns segundos
Let's give it a
para
couple of
ver,
seconds while our conference
para
technicians
hasta
are
que
taking
a
the
foto
picture.
seja tirada.
Make sure that we have the picture. Just 1 second.
Muito obrigada. Em nome do Instituto
Very
da
well. We
Propriedade
have the family
Intelectual da
picture.
União Europeia,
So, on
o EUIPO,
behalf of
do
the
Instituto
EU
da
Intellectual
Propriedade
Property Office,
Industrial do
EU
Brasil,
IPO,
o
and
INPI,
Brazil's National
da
Institute for
Federação das
Industrial
Indústrias do
Property,
Estado de
the
São Paulo, a
INPI,
Fiesp,
on
e
behalf
do
of the
Serviço
São Paulo
Nacional de
Federation of Industries, the
Aprendizagem
FIESP,
Industrial do
and
Estado de
Brazil's
São Paulo,
National Industry Learning Service,
agradecemos a
the
sua
SENAI,
participação neste
specifically its São
workshop,
Paulo chapter. We would
organizado
like to
no
thank you for
contexto do
participating in
projeto
this
de
workshop
cooperação em propriedade
organized
intelectual
in
ao InvestVerde DPI.
this
Muito
workshop
obrigada e
on the
até amanhã.
use of IPD to boost sustainable trade between Brazil and the EU. Thank you and see you tomorrow.
Thank you.
Thank you.
Thank you.